That may I have leave to mention a matter, my lord. I'm praying for leave to effect short service and for the matter to be listed, my lord, either whenever it's convenient for your lordship. It concerns a tender where they've changed, my lord, the rules of the game midway. So, my lord, it's going to be opened on the 7th of this month.
7th means Monday.
That's right. So, my lord, any of these next 2 or 3 days, if your lordship can, my lord, give us.
We hardly have 3 days. Today is Wednesday.
My lord,
Thursday and Friday are the
if
2 working days.
Friday, if your lordship can, my lord, give us, my lord,
Very well, file it Friday.
I'm grateful, my lord.
Serve.
My lord, may I have your lordship's kind leave? My lord, yesterday your lordship, my lord, had dismissed a matter on the ground of default, item number 583. I tried mentioning yesterday itself, my lord, could not, I was not provided access to, my lord. Kindly, my lord, I tried entering, but could not.
What is to be done?
My lord, kindly restores, my lord, item number
How can it
583.
be restored? The order has been signed and possibly it will be in the server immediately.
Kindly, my lord.
Nothing doing.
Yes. We have my lord's reading that on 26th of June, I was pleased to pass an order. Upon notice, I am mentioning that there are a few errors, typographical errors in the order.
Give.
Your lordship, may I mention pending relating with the contract tender?
Yes,
for
please.
inclusion.
No, inclusion it will not be allowed.
I'm mentioning.
I call my lord and I and another way my lord. So we release the matter and liberty to mention my lord. Most interesting.
What is the item number?
It's not. It's number.
Item number.
Not listed my lord.
It has not been listed. You have just filed it.
No, my lord, I go to another place my lord. Passport mention the matter.
So you want inclusion before this bench? Please come next week on Monday or Tuesday.
Monthly,
You can come and mention next month here.
I'm mentioning under compelling circumstances. Nodia Jela petition. It has been burdened with a contempt proceeding in connection with an order where we were directed to pay in excess of 80 lakhs rupees. The order was passed without adjudication and it was in my absence. We have filed an application for recall of the order. In the meantime, the contempt court has taken up the matter and the matter is fixed on 17th.
Does this bench have determination?
This recall of the order, the same determination.
Passed by this bench?
Not this bench, my lord's predecessor, has passed the order. Not your lordships. The order was passed.
And you have to approach the bench which passed the order.
For review, only in connection with review, a coordinate bench has been given the determination. But as far as recall is concerned, subject to correction, the determination lies with the lordships.
Then I have to.
There's a grave urgency, I'm facing contempt.
It cannot be helped.
I was not heard.
Tell me one thing, is it a group 9?
A group 9 matter, I'll tell you, your lordship.
Jela Parishad, you say?
The tender was in connection with
the Jela Parishad,
a property which was owned by.
I do not want the facts. Tender process conducted by a Jela Parishad, it should go before the group 5 bench.
Since the order was passed by group 9 bench, so there's some.
I do not know. How can this be done?
Since municipality is also involved and Department of Youth and Youth Services, Government of West Bengal, there was a project for installation of lights at Kolani Stadium. In connection with that tender process, there was some dispute. In connection with they have taken up this writ petition before this honorable court under group 9.
Recalling, it will take time.
Kindly, at least let it be. Any time before 17th, any time. Will not take more than 10-15 minutes, your lordships.
Can you understand what 10-15 minutes in a court mean?
I know, my lord.
Then?
My lord, may I permit to mention?
Kindly, my lord. Kindly, my lord.
At the time of mentioning for inclusion, you please mention. Today, I am not including.
My lord, some urgent matter relating to payment of dues. Petitioner rendered their service in 2021 assembly election, but till date they have not get that payment.
Yes.
The matter is running in the list. The lordship last time 16 June directed the matter will come under new heading.
Yes,
payment.
I have.
So I can help to give this number. It can come under that heading.
How many are there?
15 matters.
15 matters. All right. Give next monthly list. Next monthly list. It pay non-payment of dues. Pole diya.
Only mentioning one matter regarding wrong persecution.
Give.
Only inclusion.
Sorry, madam. Call the list.
Your lordship, may I be permitted to mention a matter, your lordship, for the modification of the order, your lordship.
Come next day.
So item number 1 is that matter where the employee of a bank has been repeatedly harassed at the hands of his own employer, Standard Chartered Bank. But in spite of payment of the entire money, my security documents were not being released. Your Lordship has granted an injunction not to liquidate
Life
the LIC
Insurance
policies.
Corporation.
appear for respondent number 5 and 6, right?
Your
Life Insurance
Lordship, the
Corporation.
bank was today to
They
take
appear for the
steps to
Reserve Bank of
produce the
India.
title deed, which they have lost,
Let us.
admittedly.
Yes, Life Insurance Corporation. What is your stand?
The petitioner was the life assured and proposer in respect of 6 number of policies, which were absolutely assigned to Standard Chartered Bank. Out of 6, maturity claim amount of 2 policies were made in favor of Standard Chartered Bank 2015. Rest 4, we have not yet, though these are matured policies in the year 2018 or 19, but we have not received the original policies. As per our policy, we have to receive the original policy from the assigned or the policy holder. We have not received the same as well as the claim discharge from. That's why we have not been able to make payment. Your Lordship, kindly see.
You, as on now, you keep the payment with you. Do not disburse payment.
Kindly see the conduct of the bank.
And what is the stand of the bank?
He is for RBI.
Appear for the Reserve Bank of
The Standard Chartered Bank, I believe she's appearing on.
For Standard Chartered Bank, it has been made clear that the 2 policy documents, as per our report that is filed, the 2 policy documents have been used. We've used it in the discharge of the loan, and the remaining 2 policies we already sent them a letter.
Madam, your sound is breaking and the court cannot hear you.
Ladyship sees the last order of 17 June.
Yes.
Para 4 records. Bank shall proceed for obtaining the certified copy of the title deed. So what steps they have taken? They have
No, there is some issue with your audio.
Am I audible now? Am I audible, Manoj?
Yes.
Yes. So it has been made clear, Manoj, in my report only that I have filed, that the 2 LIC policies have been utilized towards clearance of the loan, and the remaining 4, we've already sent them a letter asking them to come and collect the policy documents. Regarding the title deeds, Manoj, already applied to the registrar and we collected. We have not officially lost it. That is not an admission on the part of the bank. That is an admission that they've been making. In fact, if Manoj will look at the documents that they filed, it was a petitioner who was applied to the additional sub-registrar to collect the document, the policy document from the additional sub-registrar, not the bank. So there is nothing on record to show that the bank officially had the title documents with it. But anyway, Manoj, we're respecting the court's order and we've applied to collect the title documents from the additional sub-registrar.
My lord, I'm very sorry. What she's saying is completely
Please
deholds the
wait.
record. I will show the
No, my lord. You can.
This submission that you have applied and it's going to take time is coming for quite some time.
No,
I see
my lord,
the order.
last time I had sought more time to apply. This time I'm submitting that we've applied and it will just take some more time to get the document. That's it. I've applied for the title.
And LIC, you have to intimate as to what are the steps to be taken for reassigning the loan to the petitioner, because the payment has been made by the petitioner and right now the LIC policy has to go back to the petitioner. So the formalities you will intimate the petitioner. Please come.
Only one thing, Your Lordship, I would like to bring on record what my learned friend submitted is completely misleading statement. In their own report, they have stated that they have lost the title deed.
No. I did not know, my lord. It is not. We said
Learned advocate representing
Not aware of the
the
instructions of the bank.
Life Insurance Corporation of India.
We need the original policies for settling the claim amount.
The original.
In case the submission has not yet come from any side.
In case it is not available.
They are not available, then we, as per policies, we'll do.
Yes, certainly.
Bank
You
has
do not have the
documents
original.
are lying with them.
All right.
Bank has himself said that.
We've asked them to come and take the documents, my lord. This is
Representing the LIC submits upon instruction that the original LIC policies within bracket 4 are not with the authority. Stop. The As the petitioner has already cleared the loan amount, comma, the policies are required to be reassigned to the petitioner. Stop. LICI shall intimate the petitioner the formalities to be complied with for the purpose of reassigning the
Also the bank as well,
policies.
because the policies are lying with them.
The
Manoj, we've been asking them to come and
in
collect.
the
There is
event the
several
bank is
communications.
holding the original policies, comma, the same shall be handed over to the life insurance corporation
Manoj, that has been made
for
very clear. They
reassignment
come and
of
collect.
the same in favor of the petitioner. Stop. In the event the original policies are not available with the bank, comma, the same shall be intimated to the petitioner as well as the LICI so that necessary steps may be taken by the LICI for reassigning the loan amount, reassigning the policies. Stop paragraph. Learned advocate representing the bank submits upon instruction that application has already been made for obtaining the certified copy of the title deed of the petitioner and the same will be made available shortly. Stop. In view of such submission, hearing of the writ petition stands adjourned 30th July 2025. Stop. In the meantime, the bank as well as the LICI shall take steps as directed herein above.
There's only one thing I would like to bring on record, which has not been told. The bank in their own letter have said that the originals are lying with them. So now it doesn't
Item number
sound in our mouth.
No,
So-
Manoj, this has never been made.
yes.
Milord, I'm for the respondent bank.
But may I just have a word with my learned friend, Lord, because we are Lord, willing to accept what they have offered in the affidavit. So, Lord, I'll just indicate, Lord, we had filed the writ petition.
No indication. If the bank is agreeable, the court has no issue.
I'll just indicate because, Lord, your Lordship also needs to know. Lord, we had applied for closure of the accounts to the State Bank of India. Now, Lord, that representation was not being considered. Your Lordship directed them to file their affidavit and take their stand. Lord, in the affidavit, they have taken a stand that, Lord, so far as the loan account is concerned, they have indicated a figure. They are saying that updated amount, because that is taken on 30th April, updated amount, if it is paid, they are willing to accept. Number one. Number two, with regard to bank guarantee, they have said that there is a margin money that we have to pay until the bank guarantee runs its tenure. And then, Lord, once we return the bank guarantee, or Lord, if the time to make the claim expires, Lord, they will refund the money that is held by them as margin money. There is no dispute with regard to that. I'm accepting that, and I'm saying that to Lord, quantify the amount as on 30th of July and Lord, close the account on 30th July. They said that it will be suspended. The loan account will be suspended with no debit or credit, and they have a claim which is yet to be adjudicated on account of CDR, that is Lord, corporate debt restructure account. That is a claim by the consortium of the bank, and they have Lord engaged persons for the purpose of assessment. So Lord, I have this is the suggestion which I have, Lord. This is also the suggestion, Lord. Kindly ignore the word order. This is the suggestion which I am handing up to my learned friend. He can consider.
Please come. Where is your affidavit?
Lord,
Bank's affidavit? Yeah,
Milord, it has been filed.
The affidavit of the bank is on record. Stop. The petitioners have submitted a proposal to the bank for the purpose of closure of the account. Stop.
in line with their stand taken in the affidavit.
Allegedly in line with the stand taken by the bank in the affidavit. ওইখানেতেই ওই লাইনটাই কন্টিনিউ করবে Learned advocate for the bank is directed to come ready with necessary instruction. 1 week, 2 weeks.
Milord, a week,
Night.
a week's time should
One week.
Sure, we are
because
getting to 30th July.
All right.
The 30th.
2nd, 9th of July.
very well.
Released on
Let
9th.
them also indicate, Lord, the updated amount that's going to be.
Whatever is the formalities, please
Yes.
tell the figure so that it can be sorted out.
We'll take care of it.
3.
I appear for the petitioner. My lord, I'm led by a senior. My lord is on legs in another court. My lord, there's a land, my lord, which is owned by the port trust. My lord, it is, my lord, tendered. My lord, the private respondent, my lord, is in occupation under the old lease. My lord, when the tender was floated, they had a right of first refusal. They chose not to exercise it. So, my lord, I won. I was allotted the allotment letter, my lord, in March. My lord, since March, my lord, I'm to get vacant possession of the land, my lord, because I won the tender. Since March, I have not been given, my lord, the possession of the land. There are, my lord, also other, my lord, errors in the allotment letter, which I'm challenging. But since I filed the petition, my lord, there's been some discussion, my lord, with the port and, my lord, the private respondent, which is progressing. But I'm seeking, my lord, if, my lord, the matter maybe stood over for a week, my lord, I can come back next.
On the prayer of the learned advocate representing the petitioners, comma, let the matter stand over till 16th of July.
Grateful.
May it please your lordship. My lord, I appear for the petitioner in this matter. This matter is the matter wherein my account has been declared as fraud, wrongfully and illegally. Lord, with your leave, I'm being led by Mr. Shorkar. Yes.
Sir, I have served the documents.
Yes.
Showing that all the relevant documents were duly served upon the petitioners.
And I'm appearing for the RBI, respondent number 1.
Yes, please.
Lordship, we have seen the letters which was given. My lord, I've taken instruction from my
The
client.
additional documents did you consider?
Lordship, we've seen the additional documents. My lord, I've taken instructions from my clients, but there is no way that I can demonstrate because it's all been sent by email as an attachment. My client was not aware of it. Now, even not getting into that question, Lordship, my argument was that all the documents had not been served. Going by these additional documents, the one pivotal stock audit report, which was the main ground in our writ petition, these documents show that it's not been served.
The stock audit
It's
report,
not. I'll just
relying on which fraud declaration was made, was not served.
Lordship, 4 documents, 4 stock audit reports were relied on in the forensic audit report, 3 of which it appears from the documents given by my learned friend. And my lord, because there is no way that I can give evidence to support that, I'm assuming that they have been served by email, even though not by letter, which would have been the usual course considering all the exchanges were going on. Even assuming that they've been served, the 4th stock audit report has not been served, which is for that crucial year of 2023, 30th March 2023.
What is there in this bunch to show that that was served? Is there anything?
Yes, may I submit, my lord? Kindly start from page 1 of the additional documents, my lord.
The document which your learned friend is referring
to. My lord, I will show. This is the first intimation given by the auditor to the official mail ID of the petitioner, my lord. Is intimating them they have been appointed as forensic auditor and they sought for their reply on the points mentioned in this email. They did not reply, my lord. Thereafter, kindly come to the next email.
Where is it? Page 1. Where is the document that you are forwarding it?
Written by Sanjay Poddar, who is the one of the partner of the this forensic auditor firm, the CA firm, my lord, and it has been addressed to kb@bflcorp.com. That is their official Bhanu Properties official email ID, my lord.
And there are so many serial numbers.
Yes, ma'am.
Right.
These
Show
are
me
the-
that this was forwarded.
Yes, this was informations were sought for. With reference to the same, please find below the list of the documents and the details required.
All right.
Kindly note that the review period as stated in the appointment letter has been set out as 1st July 2016 to 31st July 2023.
2023.
So these are the documents which were in.
You sought for these documents.
Yes.
Now you forward. You have
Yes, I'm coming to
forwarded
that,
that.
my lord. Again, the first reminder, second reminder, then even by this letters, if my lord comes to page number 9, again a third reminder was given on 22nd November to their email, via email, my lord, and 2 documents, their initial observation and their appointment letter were forwarded by way of attachment of that email.
Page 9.
Yes, ma'am.
We appointed
Page
whether
9.
we have sent emails. And
since they did not.
Page 9 also you did not forward. Page 9 also there is no forwarding of that document.
My lord, there is stock audit report has been forwarded subsequently. I am coming to that, my lord.
Sure.
Initial, the auditors made their initial observation because they did not reply in spite of giving 3 reminders. They made their initial observation, which they forwarded. Again, at page 10, my lord, this was by way of letter. Again, the auditor sought for their representation or their informations on the points raised by the auditors, but they did not reply. All these informations, requisite informations were duly forwarded here. Then kindly come to their email, which is relevant. Now, they did not dispute, my lord, because if my lord comes to page 20, this is the email written by the petitioner, by the petitioner's representative. They refer to the auditor's previous email. And all the emails were sent on that same email ID, my lord. So there is no dispute regarding receipt of that. Now kindly come to this email at page 20. Please refer to your letter dated November 22-23 soliciting a reply against the observations in forensic audit of Bhanu Properties Limited in terms of appointment made by Axis Bank Limited. Now they sought for report of, kindly come to point A, B, and C. The stock audit report carried out on March 26, 2018, June 11, 2018, and April 30, 2022. Though these are their own documents, because these bank cannot possess documents unless it is supplied by the petitioner. So this was submitted by them only, and they sought for supply of these documents itself. Now kindly come to page number 21. We did this email, all these, the stock audit reports which were sought for, these were provided. As per the confirmation received from the bank, we are sharing the.
Oh, no, where is the forensic audit report by the accountant?
That is annexed in the, that is admitted. That is annexed in the writ petition only. With so cause notice, the forensic audit report was served upon them. After service of this, in the meantime, if my lord takes up the writ petition, during that period, they wrote to the auditor on 22nd November that these stock audit reports for these 3 years have not been served to me. Kindly supply those reports. That has been duly served by the auditor. Despite that, they did not reply. Thereafter, after the initial observation, this letter was issued that I have not been served with these 3 stock audit reports. This was supplied by the auditor, and in spite of receipt of these reports also, they did not make any representation to the auditor. They did not cooperate with the auditor. That's why the auditor proceeded on the basis of the documents available with them, and this published their audit report, final audit report, my lord.
But may I respond to that, because what's being said is factually not correct, and it's from the additional documents. Well, at first, kindly see all the documents which my learned friend showed. The relevant documents have not been shown. Lordship kindly comes to page 9 of the additional documents.
All right. First of all, you tell me,
Lordship,
which is the audit report
Lordship.
that is that according to you was not forwarded?
That Lordship will find at page 265 of the writ petition, volume 2.
Where from did you collect it?
Lordship, this is from the order of fraud declaration with which this was annexed in schedule 1.
All right. This was at the time of fraud declaration. This was annexed.
My lord, there it is said that
Mhm.
I have given stock which is not in eatable condition. That's the allegation, which according to them is fraudulent. That is based on, and I'm reading out from that particular paragraph on page 65. As per the stock audit report dated 30th March 2023, products were not in eatable condition and can be considered obsolete. However, value of said stock was shown as such and such in the books. The inconsistency between inventory and receivables reported in stock auditors' reports and financial statements. Now, Malad, the question is, when all these clarifications are being sought from me by the auditor, the existence of this stock audit which was carried out never disclosed to me. In fact, I'll show that from the additional documents. The existence of only those 3 audits were revealed to me, to which I responded by saying, I cannot respond to you unless you give me these 3 reports. Now, Malad, the dispute has arisen that whether by email these reports were served. From the emails, we can see there are 3 attachments. Now, what can happen in such cases, Lordship, when the files are too large, sometimes they end up in spam, which is why it was missed out. Otherwise, Malad, we would not be coming here in court openly and make such a submission knowing fully well that there'd be evidence on the other side. Even assuming that, Lordship, in fact, had there not been this 4th audit report, Malad, I would have had no alternative but to concede in the matter, because I would not be able to establish that I have not received it. So therefore, this is the only plinth of my argument now. I'm assuming that they have served the 3 audit. I'm not admitting it, but I'm assuming that the 3 audit reports were served. But the case which I made out in the writ petition is, you surreptitiously insert another audit report when you are trying to declare me as fraud, which is page 265. Admittedly, that has never been supplied to me. And the letter where I have asked for the 3 audit reports is because at that time, only those 3 audit reports were made known to me. If Lordship kindly permits me even 10 seconds, I will indicate the page numbers from their additional documents.
Yes, please.
Lordship will kindly see page 9 of the additional documents.
Yes.
Lordship will see page 9. This is the letter from the auditor seeking my response to certain observations made by them. Lordship will see 2 attachments. Bhanu Properties observations. Now that observations, that file is at page 10. And this is the email of 22nd November, because the reply, Lordship, which I had shown in which is annexed to my writ petition, is my reply to this email, to this letter. I'll show why. At page 10, Lordship will see this is what was shared with me. Now, please see page 10, Lordship, 1, inventories observations. Kindly see the first line. During financial year such and such, a stock audit dated such and such was carried out in the borrower account by Messrs. Agarwal Dhandania. This is the first stock audit I know. Now, Lordship kindly comes to the next paragraph. Further, in the following 2018-19, another stock audit dated 11 June 2018. This is the other response, the other reference. Now, Lordship will kindly come to page 12. And kindly sees the second paragraph. Moreover, during financial year 2022-2023, multiple stock audits were carried out in the borrower account in one such stock audit report, 30th April 2022. So these are the 3 stock audits which were referred to by the auditor. So this is what was known to me. Now, Lordship will see my response, which is page 260 of the writ petition. This is my response. It is not correct that I did not respond to these letters. And that is equal to, Lordship, the email at page 20. What I sent on email, I sent a formal letter as well. It's the same.
Yes.
Now, Lordship will see, please refer to your letter dated November 22, 2023, where those 3 audit reports were referred. Soliciting a reply against observations in forensic audit of such and such. Now we beg to invite your attention to the fact that the observations made by you are based on documents, copies whereof have not been shared with us by Axis Bank in view of the aforesaid, and in order to enable us to assist you and respond, we request you to provide us the following. So I asked for the 3 reports. Now Lordship will see the impugned order, 261. Page 261, volume 2 of my writ petition, P21.
Yes, yes.
This is the order of Fraud Identification Council. Lordship will see that ends at page 262, and that is followed by the schedules. First, the RFA is there at page 263. Now Lordship will see 264, Schedule 1, Part B, Key Findings of the Internal Investigation. Stock Audit, that's the first heading. Now Lordship kindly comes to the next page, 265, Part C of Schedule 1. This is all under what they've come up in forensic, what has come up in the forensic audit based on the stock audit. Now Lordship will see the second heading, Analysis of Financial Statements. Lordship will see the first bullet, 26/3/2018, disclosed to me. I asked for. Now it's said that it's been given to me. I'm not disputing it. 2, as per stock audit dated 11/6/2018. Again, that's the third one. Now Lordship, that's the second one. Lordship will see the next bullet, which says as per the stock audit report dated 34/2022. Again, refer
So
to.
first 3 bullets you've got.
Got.
The fourth one you didn't.
The
30th of
fourth one
March.
I have, because this is a surprise which is sprung to me in the forensic audit report. The law, Lordship, is that when a draft report is prepared or when you have observations to make or comments to seek, you have to disclose all the particulars. A to Z does not matter its order or its priority in relevance. Everything has to be given to me. Now, I am shown 3. I ask for 3. You spring in a 4 in your final audit report and you issue a show cause and then declare me as fraud. Now, there was no response to the show cause because immediately the writ petition was filed. Because at that time, my clients were not in knowledge that these 3 had been sent by email. For good and for worse, Lordship, I'm making that submission, but I can't prove it. So that's why we are proceeding on the basis as if I've received it. So we filed the writ petition, we got an interim order. So thereafter, the matter continued. In the meantime, when I see the show cause, I find that this new document. So Lordship will see that it is a part of the grounds taken in my petition itself. Because I find in the forensic audit report, which is now being shown to me for the first time, that an entirely new document has come in to buttress their claim of fraud on my part. In the meantime, thereafter, Lordship, however, the matter has been settled. I've shown the settlement documents. I've shown the Supreme Court judgments. And only
now
thing...
whether the declaration of fraud will still continue or not?
Now, Lordship, on 2-fold submissions I would have. First, Lordship, which is my primary contention when the matter was first taken up. In light of the settlement arrived at and considering the nature of settlement, especially when the amounts mentioned in your loan sanction letter is far exceeded by the amount which I have returned. Because the dispute which led to all this was dispute about levy of certain penal charges on my account. That has nothing to do with Lordship, either with the principal or the interest. I've given a chart on a previous occasion, Lordship, showing that as per their documents, they made a claim of 2 crore 40. I've paid back to 2 crore 30. So it's settled. In light of the nature of the settlement, Lordship, and this being a purely civil dispute, no purpose would be served in putting me to civil death. Lordship has seen the provisions of the circular. We have both shown the provisions. I will not be able to access the securities market. I will not be able to raise any funds, which is, according to the Honorable Supreme Court, akin to civil death, which your Lordship was pleased to observe on the very first day. So there is no purpose which will be served by putting me to civil death. This has been recognized by the 2 latest judgments of the Supreme Court, which has acknowledged this proposition and has quashed proceedings even after the criminal proceedings had been initiated. In this case, Lordship, I have approached exactly at that juncture when no steps have yet been taken.
Very good.
The judgment shown by my learned friend was a previous judgment of a bench which comprised of Justice Nath, who's on the bench in the subsequent judgments, which has upheld this principle. And Lordship knows I'm not placing the judgments formally. My learned friend will also know Rajesh Agarwal's case and some other High Court judgments following it, which is held that every single document has to be made over to me. Otherwise, there is no compliance with natural justice. And last but not the least, even assuming that there's a forensic audit report, I had shown on the first occasion the disclaimers in the forensic audit report, which would make it ineligible to be used as evidence against me. The bank would have to independently apply its mind, which the bank evidently did not do, because these documents also, they took it out from the auditor saying that the auditor served on me. The bank was required to apply its mind by looking at these documents itself, which it did not do. It merely parroted what is there in the forensic audit report and declared me fraud. There are High Court judgments that I can place, and I've prepared a note.
May I just make a very short reply, my lord? First of all, this question of new document at the time of order, this is totally incorrect.
Show cause.
If new document at the time of this order of fraud declaration, that is or so cause, that is totally incorrect because whatever document the bank has relied is mentioned in the so cause notice, same document find a place in the order. The bank issued so cause notice on the basis of 3 documents.
Your contention is all documents have been forwarded.
my lord.
There has been no violation of principle of natural
They
justice.
sought for the audit report, stock audit report for 3 years, which was duly supplied with.
The fourth one was not.
30th March was never asked for.
That is the reason you did not supply. So you admit that you did not supply.
No, they written to the auditor. They never wrote to the bank.
Whatever.
These documents, because the forensic audit report came after analysis of all the documents. Prior to that, several opportunities were given to them by the auditor to make their representation. They failed to make any representation on that. Now they cannot dispute regarding service of, because once I am using that,
it's over now. No reply to reply, please.
Yes, my lord. So all the documents were duly served. So Rajesh Agarwal will not apply in the present case, my lord. Moreover,
Very well.
the RBI has, my lord,
Hearing
on the last date I have shown the
CAV.
RBI guidelines, my lord.
Hearing concluded, CAV.
Lordship, will I submit a note if it's to my...
I don't think it will be required.
Grateful. Grateful.
I don't know.
Just now, my lord, what I have seen from your lordship's writing pattern, that is, I have remembered, my lord, my old ages, my lord, when at the time of examination used to write there, my lord is following till now, my lord is following like
what to do with so many
my lord is
matters.
writing as if nobody can see.
No, everybody can see. I'm doing it open. With so many matters you cannot keep in your mind. So little bit of points helps.
Please come.
Very good, very good. What I appear for the petitioner. The decision-making process of the West Bengal Clinical Establishments Regulatory Commission. Now, my lord, what I was challenging is, now, if your lordship sees the order, my lord, the order is at page 63. Now, my lord, the commission, my lord, does not at all come to a finding as to how, my lord, they have assessed the quantum of 5 lakhs. Now, my lord, if your lordship sees the order at page 67, my lord, it starts with something, my lord, it holds something, and suddenly, my lord, it jumps into the inference. Now, my lord, kindly sees page 67, we direct payment of the compensation of rupees 5 lakhs. Now, my lord, if your lordship sees the order as a whole, my lord, may I place the order? My lord, this issue, my lord, with regard to, my lord,
is the complainant present?
My lord, the complainant has been served with a notice. Lordship had directed, I had served.
1 minute.
Respondent number 4.
Respondent number 4.
Private.
All right. What is your instruction? Come in front. Did you file the wakalatnama?
My lord, senior has come, my lord.
Has come. Is coming.
Coming,
What?
my lord.
Coming. You are ready? No.
No, my lord.
Why? Where is the brief?
Only they, my lord.
Only
Only they.
Whoever it is, where is the brief? You not have it. You have it with you. Have you gone through?
My lord, actually, I cannot read.
You cannot read. Why? Where is the difficulty? Your glasses is not functioning.
No, my lord. Actually,
I
I could not read, my lord.
You
That is
could
my
not
first
read.
time I get the first time, my lord. I get it
First
time.
brief.
No, my lord.
Go through the brief. Come back. When will you get ready?
Okay.
When will you get ready?
ready
Tomorrow. Day after. Has Wakalatnama been filed?
Yes, my lord.
You have filed it?
No, my lord.
Yes, no, what? Have you filed Wakalatnama? Check up. Check up, please. Check. Shailesh Kothai. Please check up whether Wakalatnama has been filed or
On
not.
it, on it.
Did you file?
Yes.
তুমি
Yes.
কালাতনামা ফাইল করেছো তো
Yes, my lord.
ফাইল করেছো
Filed?
Yes, my lord.
Your color is not right. You've put it in an opposite way. Right? I'll adjourn the matter for you. Come back. All right? When?
7 তারিখে করো
Next week?
Any day, my lord.
Wednesday?
Yes.
Get prepared. I'll hear you. Wakalatnama has not been filed.
Oh.
To allow the learned advocate representing the respondent number 4 to come prepared. List the matter on 9th July.
But could it be 10th July, 9th July?
10 জুলাই আমি দিল্লিতে মামলা আছে
মানে then 7th Monday.
Monday is better. Sorry.
মানে 8th. মানে
9th.
9.
But 9th I have some difficulties.
Then it will spill over.
Kindly.
15th.
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 তুই থাকবি না আবার দুটো কিছু আছে তো 15th এ মামলা সুপ্রিম কোর্টে
তাহলে বল না স্যার
ঠিক আছে ওই অনলাইন
Yes, 2.
ওই যে ফরেনার্স অ্যাক্টে যেটা চলছে না
I am for the petitioner, my lord.
But tomorrow I appear for the Union of India. I led by learned age.
Your lordship, my lord, on the earlier occasion, my lord.
Minor gum surgery, my lord. Your lordship can take up the matter next Wednesday, my lord.
Next Wednesday.
Union is, my lord, kindly consider the answering
meantime, we should
respondent
also
will
take
be the
instruction,
bank,
my
my
lord,
lord.
from
Bank is the main.
Yes, my lord. Because this is, my lord, disbursement of family pension.
Any idea bank has any
I think
instruction?
Allahabad Bank or presently the Indian Bank is the main, maybe the answering respondent, my lord.
You are not.
I am the State Bank of India. The account was with me, according to them, not according to me,
Yes.
till 2015. My lord, we have got
Thereafter?
specific instructions that the PPO order which has been furnished,
Yes.
it is not matching with the name of the petition. It is in the name of the petitioner's father, Navadip Pal. And the petitioner has also not mentioned the account number in the writ petition so that we can ascertain whether actually we have given any money to the petitioner's account or not. There is no such record with us, my lord. My lord, may kindly have a look.
What is
to
the
this instruction
stand of
that
the petitioner? Where is the account? State.
What happened, my lord? Previously, it was the State Bank of India who was disbursing the pension.
Where is the account number from where the pension was disbursed?
My lord, this is the account.
Did you annex the passbook copy?
My lord, I have annexed, my lord, a statement of the Indian Bank, my lord, at page 40.
How will the Allahabad Bank, the State Bank get to know?
My lord, the State Bank, my lord, they disassociated State Bank for disbursement of the pension. They asked me to, my lord, open a new account with another nationalized bank. I opened an account with the Allahabad Bank. My lord, therefrom the problem started. My lord, now what happened, my lord, my sister is getting, but I am not.
Give the number of the old
Allahabad
State Bank
Bank has
number.
merged with the Indian Bank now.
Now it has merged.
Give the State Bank SBI number so that your learned friend can at least trace out the account.
The presence of Allahabad Bank is also Indian Bank is
Bank.
also necessary, very much necessary.
Yes, my lord, Indian Bank is the answering respondent, my lord.
Did you serve?
My lord, I have.
The lordship direction of the Indian Bank so that, my lord,
accommodation has been sought for on the ground of the learned ASG. Stop. The Indian Bank is not represented. Stop. Let further notice be served upon the non-appearing respondents, intimating that the matter will appear in the list on 9th of July.
My lord.
I do not
But
think
instead
you'll
of
be able
9th?
to serve by 9th. Will you be able to serve 15th? I'll keep it on 15th. 15 তারিখে রাখো।
My lord.
Or instead of 15, can it be on any other date, my lord? Instead of 15th.
16th?
My lord.
16th. Are you there?
Yes, I am.
Indian Bank.
Bank of Baroda.
Indian Bank is required.
Indian Bank is required.
Why have you implemented Baroda? Is Baroda involved
My lord,
over here?
respondent number 2 is Indian Bank.
Why is Baroda implemented?
No, no, Allahabad
What is the role of Bank of Baroda?
My lord, there were two banks in between, my lord.
Allahabad is there and Indian is there. Is Baroda also there? Please check up. Acha, learned advocate for the petitioner will forward the SBI details. SBI account details to the learned advocate representing the State Bank of India for taking necessary instruction. Have you followed? Otherwise, he'll not be able to trace out.
Baroda is a party.
No, Baroda is
Why
the-
is
because
Baroda
there were
is a party, but why is Baroda required?
from Allahabad Bank to Bank of Baroda.
Our Bank of Baroda.
Yes, my lord, there were two banks involved.
Check up.
After SBI was disassociated.
Check up the trail where it goes and where it got stuck up. এটা রেখে দিন. What is this? What is this?
My lord, I have submitted. This is the instruction that I have received from the bank.
আরে রেখে দিন, ভেতরে রেখে দিন.
Lord, may I submit the affidavit of service then?
Yes, yes. Affidavit of service.
আমাকে আমাকে অ্যাকাউন্ট নাম্বারটা দিলে আমি দেখব।
In that case, the Bank of Baroda account number also you can give so that he can also trace it out.
Try so that the Indian Bank represents.
Yes, yes.
Indian Bank will serve. Yes.
Item number 3.
My lord, I am for the petitioner in item number 3.
Respondent number 1.
My lord, may I be allowed to file one supplementary affidavit, my lord?
Why?
For subsequent cause of action in this after filing.
Subsequent cause of action will be a fresh writ petition. Why in this writ petition?
Just for informing this court, my lord, what has happened after the filing of writ. My lord,
First say what
first
the
I-
matter
first
is.
I'm grateful, my lord.
Then,
May I please matter, my lord? My lord, on 9th November 2023, my lord, there was 25 lakhs of loan transferred to the petitioner's account, my lord. And on the same day, my lord, there was a cyber attack on petitioner, my lord. A police from Mumbai through Skype had called petitioner that your bank account has been hacked, my lord.
Skype?
Through Skype, my lord. And my lord, thereafter, the petitioner was taken, the petitioner was told that there has been some fraudulent courier services sent on your behalf. So that is why you are supposed to come to Bombay Crime Police Station. Thereafter,
you went there?
No, my lord. And then I was told that the police officer will talk to me on the Skype.
All right.
And the police was there on the Skype, my lord. And then,
Could you understand the person is a police?
my lord, this is what happens, my lord. He was in the dress, my lord, in uniform, my lord. And
So
thereafter,
those uniforms are available everywhere.
my lord,
Then what can be done? And you fell in the trap.
my lord.
What is to be done?
My lord, give me 1 minute, my lord. Kindly bear with me 1 minute. My lord, the important part is on the same day, ICICI transfers a loan account, which ICICI says that it was online you had inquired for the loan. That is why we have transferred. And on the same day, this happened, my lord. Now, on 9th, I informed the bank that 33 lakhs, that is 25 lakh loan, my lord, and 8 lakh of my own hard-earned money, my lord, 33 lakh was duped from my account, my lord. I informed ICICI Bank, my lord. ICICI Bank said that I will take, I'm taking steps. My lord, may I show you the mails, my lord? If your lordship may please come to page 90.
What? You want the money back?
My lord, and not to be recovered from me, my lord. 25 lakhs, there is one DRT application being filed, my lord, to recover that 25 lakhs, my lord. My 8 lakhs from my account also has been gone, my lord, and they are recovering. They have not taken action, my lord. Though they could have easily taken an action, they would have blocked that account where the money was transferred. But they took no steps, my lord. They sat tight over it.
Let me hear.
Firstly, Lordship, if your Lordship kindly sees paragraph number 4 as pleaded by the petitioner, one
Yes.
ID proof of the officer, police officer, was shared by the petitioner at the time of the Skype chat, Lordship. So my learned friend should stand corrected that he was duped at that point of time. It is his pleading only that a ID proof was shared with him. That is there in the page number 18
ID proof
of the police official.
was shared.
Page 18.
All right. So you say the original police called.
That is what is transfers from the petition.
All right. Then what happened?
With regard to the Lordship, that amount of loan amount in rupees 24 or 25 lakhs, Lordship kindly sees page 30.
You are the ICICI?
I am for the ICICI.
All right.
Lordship kindly says that there was a complaint made by the petitioner to the office of the RBI Ombudsman, and thereafter to that particular complaint, we have given them a reply. This reply specifically stated, if your Lordship has found that page,
30?
30.
Yes.
30. Lordship, the last third paragraph.
The disputed transactions?
The disputed transactions have undergone multiple layers of authentication. Lordship, we have particularly stated them that there was a online loan application form was submitted by the petitioner, and after getting the login credentials and OTP received from the petitioner, we have only allowed such, we have only given that particular loan. This is our submission, Lordship. Before your Lordship, in that regard, Lordship, if your Lordship directs us to file a report in form of an affidavit, we will file. Only after the two-step verification process, we can only allow such.
So you were certain that the petitioner had applied for loan and not any fraudster?
There may be a fraud, but that fraud must have been happened with using the Aadhaar ID and the login credentials of the petitioner. The OTP has to be gone to the petitioner's phone number. And unless and until we get the OTP, we cannot allow such loan application.
My lord, on 9th loan is being transferred, and on 9th everything is being hacked. And there is no signature of mine online.
Apply for loan?
My lord, I have no knowledge of that loan because they themselves are admitting that it is an online application, my lord, which doesn't bear my signatures. And what has happened, my lord, it is very interesting. My salary account is in ICICI. So they have all my credentials. This is what the banks are doing. They have all my credentials. Now they are showing that I have applied online.
And what about the OTP that she is mentioning?
My lord,
get the
my lord knows, my lord, there are so many links and so many messages. Once you click it, my lord, you have no knowledge also which has been accepted, which has not been accepted, my lord.
OTP is not accepted. It has to be shared with the bank.
My lord,
again.
My lord, just for the argument, if I admit that also, my lord. But I have informed the bank that, see, this fraudulent hacking has been done from my account. The bank should have taken the steps there, and then, my lord, they should have informed the bank account to which this amount was transferred. They could have easily stopped it, my lord.
Listen, what they could have done, it is for them to do it. Now the court is not an expert in this crime matters.
My lord, if your lordship kindly comes to page 19, my lord.
No, nothing doing. Let her file an affidavit and disclose
My lord,
whatever
then
she
in the
has
meantime,
done.
they should not recover that amount from me, my lord. Because my 8 lakh has also gone from there, my lord. And my lord, these things cannot, these are not manageable in my
What about the salary that he is getting now?
To take instruction with regard to the DRT proceedings, they are stating
DRT is separate, but the salary account is there, and every month his salary is going, and
no, my lord,
the money.
Now I have stopped there. My 8 lakh rupees has also been duped, my lord. My 8 lakh.
That you've mentioned, your salary is taken care of right now?
My lord, I am from I have opened another account, my lord.
Then
that amount should not be recovered from me, my lord, till the writ petition is decided, my lord.
From their pleading only, the petitioner has got a call from the FedEx courier service, and he was informed that some parcel in favor of your name has been taken by the police authority. So you have to go for a Skype chat. At the time, during the process of the Skype chat, this is a petitioner is submitting that he was said that you transferred that particular amount of 8 lakhs rupees to your IDFC bank. So that we can say this, so that we can see whether this particular ICICI bank account is blocked or not. This was the petitioner who.
No, my lord, this is wrong. This is
whatever. Please come.
This is being misinterpreted, my lord. The police had called us to check whether my account has been hacked. That is why it has asked us to transfer some
alleges that his bank account has been hacked by the fraudsters, and the bank is regularly deducting huge sum of money on account of disbursal of a loan which the petitioner never sought for. Stop paragraph. Learned advocate representing the ICICI Bank submits upon instruction that after two-stage verification, comma, the loan account was sanctioned by the bank. Stop. Next. The petitioner prays for a direction upon the bank to refund the amount that has allegedly been swept out of his bank account. Let a report by the ICICI Bank be prepared and circulated. How long will you take?
2 weeks, Lordship.
18th of July.
My lord, one indulgence, my lord. Let them come up with the account to which the amount has been transferred, because it is their mechanism which they can easily access to, my lord.
The
And
statement of
the details
their
and the
lordship.
details, my lord, to which the account has been.
Released on 30th of July.
And Lordship,
Exception to the report may be filed by the petitioner prior to the urgent date. See whether you can trace out
Lordship.
the bank in the report, shall mention as to what steps have been taken to trace out the money
Grateful, my lord.
which was debited from the account of the petitioner.
Lordship, for that particular reason, the first amount, 8,20,000, Lordship kindly sees paragraph 10. It was the petitioner who has transferred the amount to the IDFC Bank, Lordship. They have only pleaded the same.
My lord, whatever, but my account
Basically,
has been hacked.
transferred it, Lordship.
My lord, in the meantime, no money will be recovered, my lord, from my account, my lord.
Does your account have any money?
No, my lord, but they have filed a recovery application, my lord, in the.
Let us see what is to be done. Right now, nothing doing. Yes, for.
Grateful.
Great.
My lord, there were, my lord, my lord, number of banks which on the basis of two forensic audit reports wanted to, my lord, proceed against the petitioners. My lord, the show cause notice, my lord. Firstly, my lord, forensic audit report was stayed by the civil court, by the commercial court. Matter, my lord, went up to the Supreme Court. Supreme Court said that, my lord, no commercial suit is maintainable. So, my lord, we withdrew the suit, my lord, in the Supreme Court, and my lord subsequently filed a suit in this honorable court in the ordinary original civil division. But that is pertaining to a challenge to the forensic audit report per se, saying that the report is wrong. Now, my lord, before the suit could be filed, there were around 20 notices which were issued under, my lord, the fraud circular. In my lord, your lordships have dealt with 9 of the matters. We filed 20 writ petitions challenging the notices on the ground that the documents have to be given to us. It's, my lord, or at least an inspection, because otherwise it's violation of natural justice. In around 8 or 9 of the matters, your lordships, my lord, have directed, which have come before your lordships have directed either give the documents or inspection and thereafter proceed. One of those matters was also, my lord, dealt with by your lordship, and your lordship's, my lord, judgment is there. In one of the matters, there is, my lord, an affidavit direction which was given by your lordship. But then thereafter, my lord, in another matter, your lordship said that instead of, my lord, first give the documents. After these orders have been granted by your lordships, we have written a letter to them in those matters indicating the series of documents which we require, on the basis of which, my lord, we will give an effective reply to the show cause notices. Lord, today, my lord, 2 of the matters, my lord, possibly the 10th and the 11th matter is before your lordship. I was, my lord, humbly praying for the same order as in all the earlier matters. My lord, this is, my lord, the order which was passed by your lordship. And give me the first order of Justice Bhattacharya.
Lord, the first order is, my lord, also annexed to the writ petition. Your lordships have also, my lord, wherever there has been a declaration, your lordships have, my lord, stayed or set it aside till the proceeding is continuing. In these matters, I believe there is no declaration.
No, there is no declaration.
There is no
No, no.
declaration.
It is at the show cause stage.
At the show cause stage.
All right. So your stand is for the purpose of filing a reply to the show cause, you want certain documents which the bank is to give to you. This is exactly your case.
See, exactly that.
This account has been not declared as yet as fraud.
Right.
They have set their hands over there.
Yes.
I would only add only a little point that was not taken in the earlier petition. I was not appearing there. I would like to challenge the mentality of this petition, Lordship.
No,
for
no,
the reason
it
that
is all right. But then the documents which the petitioners are seeking,
yes,
did you forward those documents?
Lordship, there was no reply to the so-cause notice.
Naturally, because unless you give the document, how
All
can
right.
you
let them ask for the
Seek
document.
for the documents.
Yes, no.
Where is the
No, no, my lord. The second, my lord, in all these matters, the second the notice, because the show cause notice has to also, my lord, provide the documents.
where is the show cause notice?
Yes, my lord. Kindly, my lord, see page 365. There is reference to, my lord, numerous events and transactions, but no document is, my lord, forwarded. Now, I am no longer in control of the company. The banks are, my lord, in control of the company today. So I don't have access.
365. Right.
So
Now
under
you tell me which is the document that you require.
My lord, in the other matters where same documents, my lord, would be required, I've given a notice. I'll, my lord, show one of those notices, my lord, where, my lord, after the order was passed, I've given them the full list. Same list would also apply here. My lord,
Lordship will kindly come to page 376 of Lordship. The so-cause notice itself is along with the so-cause notice, Lordship, the forensic audit report was enclosed upon based on which
the next matter, my lord, we have annexed one of those letters which we have issued after, my lord, the order has been passed.
Do you want the forensic audit report or do you want something
Forensic
else?
audit report I have. I want, my lord, the documents on the basis of which, my lord, the forensic audit report has been prepared because my defense lies there. And your lordships have held that forensic audit report is just an opinion.
No, it's all right. But then, did you seek for the documents that you are?
No, my lord, after your lordship gives me the leave, I will seek for them, like in the other matters.
no leave required for the Lordship. They could have just asked for it.
For giving a reply to a show cause notice, are you required to come to court to seek for documents? You could have sought. This is the show cause notice. Please forward these to me. If they don't forward, you can always come. That is all right. That is one course of action.
Yes.
But then, you immediately after receiving the show cause notice, you approached the court.
Within 7 days, I came.
Why?
My lord, in all the matters, it's the same situation.
Maybe, but then why is
Lord,
it
even
so?
today, in not one of the 20 matters, even despite orders from court in 9 matters, has one document being handed over to us till today.
That is the next stage.
My lord, I'll show your lordship.
Please give me the list of documents that you want.
Yes, my lord, please take, my lord, the next records of the next
Yes.
writ petition.
Item number 5. Show item 5, please.
Lord, in the next matter, so it.
Which page is the list?
Lord, 1133 in the next matter.
1133 খুলুন তো। এগুলো কি করেছেন?
Lord, volume 4.
ওইটা
See,
Up whether 1133 is the list of documents.
1133.
বার করো। দাঁড়া না। Yes. It is a list of documents. Now this is, Milord, this is regarding there are two reports, Milord. This is regarding the KPMG report. Milord, we've noted all the documents, more or less similar with the report of Saxena and Saxena. Two, Milord, auditors' reports are based. Milord, in another report.
And is the bank having copy of both the reports?
Milord,
The forensic audit reports we are having copy, Lordship.
Yes.
The KPMG and the
Some banks have proceeded
On the basis of those forensic audit reports, Lordship, the
তোমার কাছে
token
একটা
was issued.
তোমাকে দুটো নেই, একটা আছে। Milord, some banks have proceeded on KPMG report, some banks have proceeded on Saxena. Apart from SIDBI, which has its own report. So SIDBI I am not portfolio audit report it's called. So Milord, the first matter is Saxena. The second matter before your lordship is Milord
Here is
KPMG.
the Axis Bank. Axis Bank has which document? Which
But this is second one, Milord, is KPMG. But the first one is Saxena.
All right.
So, Milord, the list will be marginally different.
No, Lordship, I do have the copies of the forensic audit reports in
Please
both the.
forward. Either forward or
That
give
was- That
inspector.
were already forwarded to him, Lordship, along with the so-called notice.
No, the documents on which the report is prepared.
No, that has not been sought for from us, Lordship.
Now they are seeking.
No, let them. Comment to me, Lordship.
1133 is the documents required for the purpose of responding to the show cause notice and the FAR.
That is focus notice interest of another matter, Lordship, not in this matter.
No.
Not this by the bank.
Milord, may I explain? That is, Milord, in respect of a KPMG audit.
Please come.
Milord, may I show your lordship, Milord? I'll give him a list,
The
Milord,
petitioner.
within 2 days.
Challenges. The show cause notice issued by the bank seeking to declare the petitioner as fraud. Stop. The primary contention in the writ petition is that the documents relied upon by the bank for issuing the show cause notice have not been served upon the petitioner. Stop. The petitioner alleges violation, petitioners allege violation of principles of natural justice. Stop. Paragraph. Learned advocate representing the bank submits upon instruction that the petitioner never sought for the documents. Stop. Paragraph. Leave is granted to the petitioners to forward a list disclosing the documents required for the purpose of giving a reply to the show cause notice. How soon can you do it?
Today, it's ready.
Stop. এই যে বললাম কি বললাম
Leave is granted to the petitioners to forward a list disclosing the document.
Advocate letter তোমায় দিয়ে দেবো আজকেই।
show cause notice by আজকে তো 2 তারিখ 4th July. Stop. If such a request is made, then the documents sought for by the petitioners be either forwarded to the petitioners, and if the documents are voluminous, inspection of the documents shall be provided to the petitioners or their authorized representative. Stuff. Next. The matter can be disposed of on the matter can be disposed of on
Lordship, I was only relying upon one judgment of the Honorable Supreme Court, Lordship, on the point of maintainability of writ petition against private bank. May only rely upon that, Lordship. Lordship, it's a decision judgment of January 2025.
But you're acting under powers conferred under a circular of RBI. This may not really apply.
The RBI circulars and the Banking Regulation Act are only regulatory in nature, Lordship. The judgment says.
Yes, this is only regulatory in nature. This order is a type of a regulatory in nature.
I bow down, Lordship.
Nothing is being decided.
Lordship.
It's only A direction upon you to forward documents or to provide inspection.
It was my duty to Lordship, bring it to
I
kind
am
notice.
aware of it.
কোনটা
আচ্ছা,
দেখা আমাকে
কি
দেখে
হলো?
আমি জানি কিনা
দেখাবো,
দেখা না
পরে দেখাবো,
কবে
অবশ্যই তখন দেখাবো যে।
হ্যাঁ।
না, না, না,
At the earliest.
উচিত।
Stop next.
তুমি কিন্তু কাউকে দেখাবে না, তোমাকে দেখাবে।
আমি জানি ওটা।
অবশ্যই তুমি
The party shall thereafter take steps in the matter in accordance with law. Writ petition stands disposed of.
Lordship, will there be any time bound matter, Lordship, within which?
They will do it by day after tomorrow.
Yes.
4th. You forward at the earliest.
Then proceed.
Thereafter act in accordance with law.
Grateful. In fact, in the other pending writ petitions, I'll issue this similar notice to get today.
4 and 5, same order. Next time, be careful. The maintainability point will be taken care of.
But I hope the other matters are all nationalized banks.
Keep hoping. মানে ভলিউমিনাস পাঠানোর দরকার নেই, অ্যাপিয়ারেন্স গুলো প্রপারলি নিয়ে নেন।
Grateful, Vilas. Both matters.
Both matters.
Yes, 6. দেখি এটা পড়ে যাবে তো। Petitioner, madam.
My lord, may I be permitted to hand over
Yes.
SBI Life own shareholding pattern published by them only. On page, I have only taken the relevant extract pages and page 3, my lord. My lord, will come to page 3, my lord.
Yes.
The first line, first shareholder's name is SP, State Bank of India, and percentage of shareholding is 55.40. It is their own publication.
Yes, what is
Yes,
your
my lord,
submission?
on the last occasion with regard to maintainability, my learned friend has, my lord, relied on, my lord, 3 decisions. Lordship will kindly take up the decisions at page 16 of that bunch.
Yes.
My lord, this is by one, at the very outset, my lord, I say, my lord, all 3 decisions, all we have preferred SLPs and all the orders have been stayed.
All the orders have been
Yes, I have the orders, I'll place them one by one. Lordship
Okay.
kindly says, it sees page 16. This is, my lord, venue. We had preferred a review by SBI Life Insurance against venue. My lord, this venue case has been stayed by the Honorable Supreme Court. I'll place the orders. Venue, first one.
Page 17, you can see MG Venu.
11. Notice. My lord, this is venue's first order. আপনার দিচ্ছি, কপি দিচ্ছি, কপি দিচ্ছি। এই যে venue. My lord, this is 6/11/2017. My lord has seen.
Yes.
My lord, may I need to place this?
No, I've seen that
Yes.
it is stayed.
Yes. Now, Lordship will kindly consider the next order passed in
The
venue.
question whether SBI
Yes,
Life
absolutely on this
Insurance
question.
can be termed as a state.
Right, and Lordship will kindly find this 6/11, this tag with SLP number 15696 of 2016.
Yes.
But this is Bhulan Ram, the other case that has been relied on by I'll place that also. But this is venue's next order.
Yes.
11th July. They had preferred an application for vacating of the interim order. That's what that was dismissed. This is the interim order. It has got it.
This is the interim order.
Lordship, will kindly see whether that is Venu case or not.
But this is not Venu. This is Virendra Pal Kapoor.
I'll give it. Lordship keeps that.
Virendra Pal
But
Kapoor is page 19.
This is Venu's next order.
MG Venu. Application for vacating interim order is dismissed.
Dismissed.
Yeah.
So, my lord, these two are Venu's order.
Yes.
Then, my lord, this Venu passed by the Honorable Court, my lord, relied on two decisions, one of the Allahabad High Court and the other of the Patna High Court. My Allahabad High Court decision is Dr. Virendra Pal Kapoor, that one.
That is, you have given.
Lordship has got that order of 11th July 2014.
Yes.
Impugned order has been stayed. I'm giving my learned friend a copy also. দিচ্ছি 11th July. এটা হচ্ছে Virendra Pal Kapoor. Then, my lord, this is the latest order. এটা একটু স্টেবল করে দিন, একটু স্টেবল করে দিন। দুটো অর্ডার একটু স্টেবল করে দিন, দুটো পেজ আছে। এটা দুটো পেজ আছে। This is the last order. This is basically before the registrar bench on 6th May 2017. But certain directions have been passed. That is all right. But this is pending. And my lord, the other one, the third decision, Bhulan Ram. Bhulan Ram. This 26/9/2016. But this is the first order of Bhulan Ram. Bhulan Ram. My lord has seen Bhulan Ram, the same issue.
Yes.
To notice returnable after 4 weeks, limited to the question whether the SBI Life Insurance Company Limited can be termed as a state within the meaning of Article 12. In the meantime, there will be a stay of operation of the order, impugned order and judgment dated 28/4/2016, passed by the High Court, subject to condition the payment already made by the petition company not to be recovered at this stage. Bhulan Ram next order is 26th September 2016. হ্যাঁ দিচ্ছি এই যে these are the all orders that are available. So the matters are pending, and specifically on the point that as to whether this can be, so what I humbly beseech your lordship is, since the Honorable Supreme Court is insisting of the matter, so decision has to be taken by the Honorable Supreme Court. Until that,
listen, these are pending from 2014.
My lord,
11 years, you cannot expect the writ petition will be kept pending over here. What is the decision that you are relying upon, that the SBI life insurance cannot be treated as the state under Article 12 and writ will not be maintainable?
No, my lord, the issue is, that is to be decided. That is the question of that is pending before the Honorable Supreme Court, and that is to be decided.
Pending is pending.
My lord, so right now,
your submission is that it is not state.
I cannot say that right now. I have to rely on the Supreme Court decisions since the matter is pending before the Honorable Supreme Court. She has, it was a specific lordship's last query before the learned, before my learned friend was that she has to satisfy your lordship with regard to maintainability. Right. She relied on these 3 decisions, right. But I have satisfied your lordship that these 3 are pending specifically on the question of law as to whether, and also facts as to whether
that means your submission is that SBI against SBI life insurance, no writ will lie.
Yes, that is my submission.
Right. Give the decision that you are relying upon in your support.
But in that event, I have to come back with.
You must be having some.
Right now, I have these three. Because these three, my learned friend had.
This is to controvert the petitioner.
Right.
What is in your support? You show me those judgments which are in your support.
That might have to check up.
What is the?
But then I have to check up. You have to check up.
What is the prayer of the petitioner over here?
My lord, the main crux of the matter is I have my insurance policy have matured, and when they have asked me to submit the documents, I have submitted all the documents. Only the original policy documents found to be missing. So according to their rule, I have given the indemnity, and my daughter is the surety. Their problem is they are not allowing my daughter to be surety because she is related to me. But I have given enough, and whatever.
What is the?
Lordship kindly takes up page 56. The policy. Lordship kindly takes up the document which I had
The original is not there, and if a surety.
That is original is not the issue here.
Surety, if surety.
Surety is the issue, and NOC from the employer is the issue.
Employer.
Right. Employer. This is my conditional assignment. This is not a simple policy that she has paid the money. She has not paid the premium. It's a one-time premium paid by the employer on the condition that on the date of maturity, this employer has to be in the payroll of the employer. That is why we require this NOC from the employer. And which is at page 56, we have repeatedly asked her these three documents. NOC letter, page 56, like you kindly see.
Yes.
NOC letter from Gujarat NRE Co, that is the employer. Yes. Surety from third party not related to PH by blood, and past communication. But these two documents she has to give us, and she is insisting that I am not giving to you.
My lord.
1 minute. Page 56.
Yes.
This email is not from SBI. Where is the request? NOC from the Gujarat.
NOC from, yes, that is the employer.
Third party not related
yes.
to the person by blood and past communication. NOC is not there.
NOC is not there, and this third party surety is also not there.
My lord.
Yes.
May I show you, your lordship, page 18 of my petition, my lord, which is quite clear that this policy was purchased by the then Gujarat NRE Co on the employer-employee insurance policy with SBI Life, my lord. And I am, my name is still appearing in the Ministry of Company Affairs, Corporate Affairs, as the director of the Gujarat NRE, my lord, that I have submitted with my petition as well as with my written notes of argument, my lord. And I have not left the company. The company is under liquidation before NCLT, my lord. I am still there as in the list also. I am still there as director, my lord. And Gujarat NRE's letter specifically says, this is to further confirm that the company would have no
All right, 1 minute. The company right now is under liquidation.
Let her get a certificate. Let her get a certificate from the liquidator. But without this we cannot proceed.
Your liquidator can help you out.
Yes, that is what I'm making assumption.
You can obtain the certificate from the liquidator because you do not have an employer right now. Company is in liquidation. Obtain a certificate from the liquidator that the company is under liquidation, so that the SBI life insurance can at least proceed with your claim.
My lord, in any event, yes, my lord.
In that case, can the liquidator stand as a surety? I am
that
not sure.
I do not know, but we have our own guidelines. We have to follow that. We cannot go beyond that.
Provide her the guidelines so that she can take.
My lordship, on the last occasion, I had handed over to your lordship, my lord, the conditional assignment. Lordship kindly says the specific condition is that the assignment shall stand automatically cancelled, and all rights, title, and interest hereunder shall revert to the company and vest in the company automatically and unconditionally in the event the employee, that is the petitioner, leaves the company on or before the maturity date of policy. So, my lord, the maturity is on March 24, 2024.
That has matured.
That has matured. But we do not want to hold on to any policy, anything. But let her give these two documents. We'll hand over everything.
The petitioner is not in a position to give the documents.
But then how can we? But if tomorrow the company comes and holds us liable, then how can we protect ourselves? This is, lordship will kindly consider. This is.
Why don't you guide the?
I told her repeatedly. We have been asking. we have been asking the petitioner to give these two things. One is the NOC from the company.
Now the company is no longer.
Let her get a
existence,
certificate
it's
from the.
under-
Let her get a certificate from the liquidator. Let her approach the liquidator.
Please come.
My lord, in any event, my lord, my humble submission is the last line suffices that they have no objection in any event if the maturity amount is handed over to me. My lord, this letter is very
After
clear.
the amount has matured,
My-
why do you want all these things to
No,
be
no,
complied with?
but we have to make the payment that has to be transferred to somebody's account. So, my lord, on the date of maturity, the conditional assignment says he has to be there on the payroll of the company. That is why we require this. That is why we require this.
My lord, payroll.
You can always find out that
Madam.
the company is no longer functional.
But that we cannot.
we have
Well,
any
that we
documents?
cannot. We cannot go and make inquiry over there. My lord, she has to bring these documents. She let her approach the liquidator. Let us see what the liquidator says.
Acha, लिखूं तो?
But regarding the Ministry of Corporate Affairs list, my lord, I can show that my name is still there as director. So I have.
Let her get a certificate from the liquidator.
The learned advocate representing the respondent authority relies upon the decisions of the Honorable Supreme Court in support of the submission that the judgments relied upon by the petitioner have all been stayed, and the issue as to whether SBI Life Insurance Company Limited can be termed as state within the meaning of Article 12 of the Constitution is still pending consideration. Stop paragraph. The insurance policy of the petitioners, comma, though matured, comma, have not been disbursed because the petitioner is not able to produce document to show that the petitioner is still in the payroll of the company.
But not still on the date of maturity.
Acha,
On the date of maturity of the policy.
that the petitioner is কি বললাম একটু বলুন
That the petitioner is
to show that the petitioner is in the payroll of the company on the date of maturity of the policy. Stop. It has been brought to the notice of the court that the company is under liquidation.
By the petitioner. This is a submission.
Yes. And but the name of the petitioner still appears as director in the records maintained by the Ministry of Corporate Affairs. Stop paragraph. The respondent is directed to intimate the formalities that the petitioner is required to comply. As right now, the company is under liquidation. Stop. Intimation shall be forwarded by 11th of July. Stop. The petitioner shall comply with the formalities as formalities to be indicated. Stop. Next. Release the matter for further consideration on 29th of July. You please let the petitioner know what is to be done.
Now that the things have changed, the company is in liquidation.
Yes.
I have followed your lordship. Grateful to your lordship.
Lord, in item number 7, Lord.
Item number 7, Mr. Shidatavanji is appearing for the petitioner. I am praying for a short passover since he's on your list.
And today, I make it not to it. Yesterday I said for the entire day it was passed over. Your lordship called up
at the time of rising, even
And
then.
I kindly allow me to join one more issue here, my lord, that I am appearing. I have been instructed to appear on behalf of the respondent number 8. On the same ground, the husband of the writ petitioner and the writ petitioner, my lord, filed a civil suit before the learned civil judge junior division Kandy. No. So they are admitting it's a civil dispute, and now they are
Do
agitating
not
the same.
open the case. The petitioner has not opened the case, right? What do you want? Adjournment. Where is the advocate on record? Passover will not be given. Yesterday also it was the same thing.
For the entire
The learned advocate was present for the whole day.
Okay.
Why don't you start? Yes, what is it? Petitioner claims to be the mother of one Mansoor, who was an army personnel who expired. Specific is that the son was unmarried bachelor, claiming to be the petitioner's global marriage with the petitioner's son. State was supposed to take instruction.
I have taken instruction. I have taken instruction.
Give.
The
What is
instruction is, my lord, the act does not say that the particular MMR has to register the marriage in a particular area. There is no provision in the act itself.
You mean to say whoever is the MMR in Kolkata can register a marriage in Badwan?
Badwan. In the act there is no provision, my lord.
But then you are appointing MMRs for particular police areas.
For the benefit of the people, so that they cannot have to run here and there. Only for this purpose. There is no jurisdictional part. There is no jurisdictional part. Kindly consider the 1876 Act, my lord. There is no jurisdictional part. In the Act, my lord, surprisingly, the Pre-Independence Act is there and there is no jurisdiction part.
Very well. Assuming there is no jurisdictional bar, where is the appointment letter of that Qazi who registered the marriage? Was anything mentioned in that certificate that you will not be able to register marriage outside this jurisdiction?
There is no mention also.
In that marriage, the MMR certificate, there is nothing?
No. The IGR has checked up.
You checked up?
The IGR has checked up.
Yes.
That means I checked up.
Then there will be an anomaly.
No, my lord, I am for respondent number 9. My lord, may kindly have a look at the act, my lord, section 3 of the act.
Yes.
Who is the respondent number 9?
I am the wife.
You are the wife.
On the last
Who are you?
I am, my lord, the particular Kaji against whom
Somebody appeared on
Yes,
behalf of
my
the
lord, I
Qazi.
have been entrusted the brief yesterday evening.
Oh,
I have been entrusted with the brief, and my lord, I just want to join one more issue. That is, my lord, it's a Muslim marriage. My lord is well aware, my lord, that a Muslim is it's a Mohammedan personal law, and my lord, in Muslim personal law, my lord, a oral gift is a valid gift, and in the same way, the Honorable Supreme Court says that, my lord, and the same way, my lord, the oral marriage is also a valid marriage. So, my lord, if the parties verbally agree before any Kaji anywhere in the country that yes, we agree that we are married, then, my lord, it's the valid marriage.
Within certain specified limits.
That point, your lordship. On the last occasion, it has been so, your
Within
lordship.
certain specified limits, which means you cannot register it throughout.
That is the
On application being made to him for such registration, there must be some limitation.
I'm kindly sees the proviso also, your lordship, where it says that when there is
No more than 2% shall be licensed to exercise within the same limits, and provided further when the two are licensed, where one shall be members union.
But limits
Only
here,
in
my lord,
case of-
limits here.
Or,
If your lordship is not satisfied, I can bring the report with that clause, my lord. The limits means, my lord, my lord, kindly assume if that is that the bride or bridegroom is not entitled to marry, they are not up to the age limit
prohibited relation.
That is not
or
limit.
they are not
That is the ineligibility.
ineligibility.
But then that is not limit.
But that
No,
is
no, no. You're. Well, what does the proviso mean? Then the proviso does not have a meaning at all.
Let me kindly see page, the annex page 34,
My lord.
the limit is given, my lord.
I'm on that.
Kaji, my lord, the limit is third and fifth, undoubtedly, my lord.
Yes.
No. There is no limit
Right.
specified. No limit
The reason
specified.
every police station has one Qazi.
There is no limit
Otherwise,
specified.
No,
There
no.
has
Limit specified.
Otherwise, there would have been no Qazi.
The submission that the state is making now
Yes.
will go contrary to all matters where everyday matters are being moved. For a particular police station, a Kaji is to be appointed. And now you say Kaji can, then there is no
Appointment of
requirement.
appointment of Kaji within the territorial jurisdiction of a particular police station. But the marriage to be solemnized, there is no jurisdictional
What
power.
is the use?
For
Then
you,
there one marriage registrar may be there who can register marriages throughout the state.
there is no bar, my lord.
But kindly see page 35.
And not only the state, it can go. This is a central act, it will go throughout the country.
But there is no bar, my lord.
No,
there is
it's
no.
absolute wrong interpretation. It can never be. Well,
My lord, may I humbly submit, my lord?
yes, please.
My lord, there's a basic difference between a Hindu marriage registration and the Muslim marriage.
Yes.
Yes.
In the Hindu marriage registration, marriage can be registered only at the place of the residing where the husband and the wife is residing. But in Mohammedan marriage registration, my lord, it has to be compulsorily registered in the place where the marriage took place, my lord, irrespective of where the parties belong from. Supposedly, my lord, a husband belongs from Kashmir and the wife belongs from Kerala, and they solemnize a marriage in West Bengal, supposedly before Calcutta marriage. So, my lord, it has to be registered before Calcutta, not, my lord, before someone being a Qazi in Kashmir or, my lord, Kerala.
Thing is, the person who registered the marriage.
Well,
Yes.
sir, what your lordship has not been, what has not been brought before your lordship, that is prior to, my lord, the certificate. My lord, there is a cabin nama, my lord. I am giving a.
Admittedly, they got engaged. Admittedly, they got engaged.
No question of engagement, my
They
lord.
got engaged, admittedly.
No,
My
they
lord,
have got engaged. That I have stated
What?
in
No.
my plea. But they are not married. And for that reason,
And
my
my lord,
civil suit is pending.
yes,
I am not
then-
on the point of marriage, your lord. I am on the point of the registration of the certificate.
But that
That
means
is my
marriage.
case.
That means
That
marriage.
is my
That
case,
point
my
has
lord.
been agitated to the Supreme Civil Court, my lord.
If you know that your volume is more, do not use a microphone. Just
No.
remove it from there and then you can speak. Please come.
my lord, may kindly see the place of
But
marriage, that is office of the marriage registrar.
Subhato.
And my lord, this has been registered before that marriage registered. Anyways, my lord, this certificate is valid. This certificate has not been produced before your
Acha.
lordship, my lord, in the written.
I have heard the submission made on behalf of all the parties. Stop. It transpires that there is an issue with regard to the factum of marriage. Stop. According to the petitioner, though an engagement took place between the son of the petitioner and the private respondent, comma, the marriage never took place. Stop. Learned advocate representing the private respondent submits that the marriage did take place. Stop. Paragraph. The whether the benefit can be whether the terminal benefit of the deceased son of the petitioner can be passed on to the petitioner or not depends upon the said issue of marriage of the deceased employee. Stop. As the marriage is disputed, comma, the court is not in a position to provide any relief to the petitioner. Stop. The writ petition accordingly fails and is hereby dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioner from approaching the competent forum for redressal of her grievances in accordance with law, if so advised.
Madam, I have already filed. The civil suit is still pending, your lordship. Otherwise, the benefit will be transferred to her, your lordship.
Please call the next matter.
Kindly add online not to give effect to that benefits, your lordship. Otherwise, I will be nowhere, your lordship. Kindly.
Can you not obtain this order from the civil court?
But a civil suit is pending.
Yes. Can you not obtain this interim order from the civil court?
But your lordship, I am on the
This,
point of.
this court is dismissing the writ petition with an interim order in your favor. Please. The interim order stands vacated.
Item number 8.
Item number 8, on the last occasion, his lordship directed us, my lord, to file a fresh report with regard to this bank
Please,
fraud,
your
my lord. So far,
lordship, I'm for the writ petition.
petitioner has purchased the property and
May I-
someone claims that.
May I have a copy of the report filed?
Lordship, in this matter, Ms. Corner also will appearing before respondent bank lordship. She has engaging and led by Ms. Lordship.
So far, the report is concerned, my lord.
Give your name and not anybody's name who is not present in court.
ওই ইনভেস্টিগেশনটা চলছে ব্যাংকেও ডেকেছিল এসব
Documents needed, section 92. My lord, may I pray for some time to go through this?
না না দর্শককে দেখতে দে ছোট্ট রিপোর্ট 3 পাতা
Amount আমার মিলছে না।
Stating the
34 না 36 লাখ 9 সাথে 16 36
না না
লাখ
29 হবে। ইস্যুয়েন্স হচ্ছে 29 এর।
Please come.
My lord, I have also, my lord, bring, if lordship so require, my lord, the photocopies of the CD. The case diary is with me also.
My lord, I was also, I'm praying for an extension, a continuance to file my supplementary affidavit and go through this and include a paragraph in my supplementary affidavit.
The report by the officer in charge, Topshia Police Station, dated 1st July 2025, filed in court today, is taken on record. Stop. Copy of the same handed over to the learned advocate for the petitioner. Stop. It appears that the police is investigating the complaint lodged by the petitioner. Stop. The learned advocate seeks extension of time to file the supplementary affidavit. Stop. Release the matter for further consideration on 12th August 2025. Further progress in the investigation shall be reported before the court on the adjourned date.
Though I have not filed any application.
Who are you?
But I am the Union of India, my lord. The respondent
Union of India?
Lord, maybe expunged, my lord.
No, my lord, I have something to say which is not against the Union of India, but they might be able to assist. Because in the last occasion, your ladyship was looking for a resolution to.
Okay, this is a petition.
No, no,
Petition, Lord, against respondent number 1.
There is nothing against you. Stay here.
Further in report check. 12th August, lordship.
My lord, Mr. Banerjee can also happily come and bill. My lord, his appearance is required at a later date.
Yes.
You might go to Supreme Court.
Number 9.
Get 9 is my application. My lord, this is with regard to my lord, a file, criminal file that was not traced before the. Yes, now my lord, this is the last order certified copy of the order. But I have provided all the documents to the trial court. The file has since been reconstructed. So I'm really grateful that my lord's order has created magic.
So your grievance is resolved?
Yes, for the time being, only one extreme intelligence was seeking. Well, let there be no direction by your lordship upon the magistrate. Only thing, Lord, if your lordship kindly makes some observation, if I give my account number to the learned magistrate, Lord, the payment from the opposite party may be directly.
No, my lord, for that, my lord, he needs to file the execution.
I am filing the application, but there are certain difficulties outside the courtroom because she will receive money, lordship, I appreciate, from 2010. It's a hefty amount. I'm not there. She is being insisted.
Make a prayer before the court below.
Lord, he needs to file the execution procedure.
Well, because she is to receive a quite a lump sum amount.
The money will go to the bank account, whether it is by this court's order or by the magistrate's order.
Some observation.
I do not know what the matter is. You paid for reconstruction, it has been done, the matter ends.
This is a maintenance matter under 125 CRPC.
Whatever.
The husband to the wife, some observation,
Right.
some observation,
Right.
only observation, only observation. That I'll make a prayer and I'll make a prayer. Yes, I'll make a prayer before the court below and the court will consider.
It has been brought to the notice of the court that the file which was not traceable has been reconstructed. Stop. It will be open for the learned court to to take necessary steps to dispose of the prayer of the petitioner. Stop. It will be open for the petitioner to raise all issues before the learned trial court. Petition disposed.
But including that bank account, only Lordship kindly writes that only.
What thing, including?
But including that she will provide the bank account details before the landed magistrate and the magistrate may direct the.
I am not understanding why you want this to be written in the order. The moment you make all these things, then a lot of things goes in the mind of the court as to why this is being made. It's better you go and
outside the courtroom, they are insisting that that amount may be paid to the court. Whereupon she will be able to collect that amount. Lordship knows what is happening.
It will be open for the petitioner. No. It will be open for the learned court to decide as to whether the money receivable by the petitioner may be transferred directly to her bank account.
Milord, only one thing, my report may be kept with the record, Milord.
Yes.
Milord is keeping that certified copy of the order on the record.
I do not require. Take it back.
I have a photocopy.
Why will I keep it? You say it is you have reconstructed certified copy. Ferat diye din ki High Court report ache ota rekhe din. Let the certified
copy of the report from the High Court.
The record has been reconstructed.
No. Grateful to Lordship. Obliged.
Yes, next. Yes.
Lordship, I am appearing for Aditya Birla Finance, Lordship. I am being led by Mr. Sagar Bandyopadhyay. He is on his legs, Lordship, before Court 11. I am praying for a short passover.
Because there was a wrong submission made on the last occasion. Kindly have a look at my Lord's last order. I am opposing this prayer because there is some urgency. I understand he is on his legs because he is against me in that matter. I have left that and I'll come here to do this. But if your Lordship just looks at the last order, I'll take some time, Lord, because by then I'm hoping he'll come. I'll just show two things. Kindly have a look at the last order, Lord, 24th of June, 2025.
Is out of session. Kindly make it not this week.
Who is out of station?
Advocate General.
How is he involved?
Advocate General.
Is the AG required?
State of West Bengal, the impugned order is by the learned Chief Judicial.
Is the presence of the AG required? Who is appearing for the state?
So he must be appearing in some different matter. Kon mamla kotha bolche?
Who is he appearing for? Who is he?
14 order has been challenged. I unlikely that the Advocate General will come for the.
The state has been made a party.
Who is he representing? Who is the Advocate General representing?
That I don't know, Lordship.
You should know when you make submission as to who is he representing. Somebody must be assisting the AG if he's appearing for the state. Is he appearing for any private party? Aditya Birla is over here.
Aditya Birla is the financial, is the credit.
Aditya Birla is represented.
District
Then who is
magistrate.
the AG representing? Are you sure before this court the AG is appearing in item 10?
Yes,
Or in some other matter?
No, item 10, Lordship.
Who is what is the name of the your client? Inquire. Yes.
Yes, kindly have a look at the last order, Milord. Please disregard how my name is spelled. Learned advocate representing the petitioners relies upon a judgment delivered by an honorable single bench of this honorable court. Learned advocate representing the private respondent, Mr. Bandyopadhyay appeared, submits that the said order has been set aside by the honorable division bench and the matter has been remanded back to a learned single judge for reconsideration. The same is pending till date. Incorrect. I'll tell you, Lordship, what has happened here. Notice 13.2, 13.4, section 14 challenge. Section 14 order. Section 14 possession taken. 13.2, 13.4 challenge by way of a 17. 14 when it's taken. Challenge by way of an application. Section 14 order that challenge dismissed. This is with regard to a property which is somewhere in Balashat. BT Road. Somewhere else, I have another property in Kolkata. So now they apply before the Metropolitan Magistrate Kolkata to take possession. And
Of which property?
properties
Of the
which are in
Kolkata
Kolkata,
property.
other properties, not the subject matter of this application.
All right.
There they disclose, along with the application under section 14, which I now get is corroborated by the information that they've supplied to me, that my authorized officer who had gone and taken possession under the section 14 order was actually the legal manager. This bank, this particular financial institution doing the same thing, my Lord Justice Bhattacharya's order was there, which I wanted to rely upon. In a writ petition which has been set aside, possession directed to be restored because this is absolutely without jurisdiction. This is 2A of the rules. Your lordships have laid down that the
How
authorized.
is that related to this?
Because in my matter,
yes,
possession has been taken again by this bank by authorizing the legal counsel, regional manager, and the junior legal counsel as authorized officer to go and take. If your lordship looks at this order, it has been held because of 2A, rule 2A of the securitization rules. কি করছো ওটা?
আমার কপি রাখতে চাই।
আমি এক মিনিট জজসাহেবকে দেখিয়ে দিই, আরো কপি দাও, আমাকেও দাও। No, this is the order you'll actually kindly have a look at. Yeah.
Thank
you. This bank only, huh? HSBC, Aditya Birla. And it was Aditya Birla itself which was there at sorry.
But there is an issue with regard to the maintainability that has been raised. I see a judgment record, private respondent has.
Yes, and that has now, if your lordship just turns over, my lord. Paragraph 13 of this judgment, which I've just handed over, dated 31st August 2023.
Right. Yes.
Learned counsel places reliance on judgment of the Supreme Court at 2022 10 SCC 286.
Yes.
It was held by the Supreme Court therein in the context of adjudicating whether a learned advocate was competent enough to come within the purview of subordinate officers of a district magistrate or chief judicial magistrate, that while entrusting the act of taking possession of the secure assets consequent to the order passed under section 14 to any officer subordinate to him, the CMM or district magistrate ought to exercise prudence in appointing such persons who will be capable of executing the orders passed by him. It was also observed that merely because he has power to appoint any officer subordinate to him, it would not permit him to appoint a peon or a clerk who is incapable of handling the situation. Learned counsel next argues that a person who has affirmed and moved the application under 14 on behalf of the secured creditor was not legally competent to be appointed as an authorized officer. In the facts, in such context, learned counsel places reliance on the definition of authorized officer in Rule 2A of the 2002 rule. The facts here are identical to the facts before your lordship. It's just.
Then will the writ petition be entertainable?
Yes, this is also considered. I'll show that to your lordship. It is argued that the petitioner applied under section 17 at the stage when symbolic possession was taken. As such, there was no occasion or threat for the petitioners to apply for an interim order at that stage. Subsequently, it is argued that Office of Chief Judicial Magistrate served an incomplete copy of the application where one of the pages was missing. Even today, no complete copy of the application has been filed. Lordship will kindly turn over, my lord, to what the ratio is. Paragraph 23. Sorry, 24. The context of the observations of the Supreme Court cited by learned counsel can only mean that a peon or clerk who is incapable of handling the situation will not be appointed. The stress in the said observation is on the expression incapable of handling the situation and not peon or clerk. In fact, the process servers is evident from the rules of 2015 cited by the petitioners themselves, a part of the process establishment equivalent to bailiff, summons bailiff, seal bailiff. In the present case, a seal bailiff was appointed to take possession, who was appointed specifically trained and competent to execute orders, thereby fully coming within the zone of competence as contemplated by the Supreme Court. As such, the objection of the petition is turned down observing that a seal bailiff was sufficiently qualified and competent to be appointed by the district magistrate. However, a more discordant note is struck by the petitioners vis-à-vis the extant rules when the petitioners rely on Rule 2A of the 2002 rules. It cannot be gainsaid that the authorized officer as per the said definition means an officer not less than a chief manager of a public sector bank or equivalent or any other person or authority exercising powers of superintendent direction and control of the business or affairs of a secured premises as the case may be. The principle of ejusdem generis fully applies to any other person or authority as provided in Rule 2A, which demand that a said person or authority has to be equivalent rank as chief manager of a public sector bank. In any event, the definition also clarifies that the person or authority has to have powers of superintendence, direction, and control of the business or affairs of the secured creditor. By no stretch of imagination can it be said that a legal counsel of a financial institution exercises such powers as envisaged under Rule 2A. The reliance placed by the secured creditor on 1312 of the Act is misplaced, since the same clearly stipulates in no uncertain terms that the rights of a secured creditor under the Act may be exercised by one or more of the officers of a secured creditor authorized in this behalf in such manner as may be prescribed. The word prescribed here specifically refers to the rules of 2002, which has given a specific definition of authorized officers indicated above. Thus, such argument of a secured creditor cannot be accepted. It is palpable that the concerned person, that is the legal counsel described to be so in section 14 application itself, had no application and qualification under the law to be appointed as an authorized officer by the secured creditor. Hence, the entire exercise undertaken by the said person in the capacity of an unauthorized officer was dehosed jurisdiction and without authority, including the filing of the application under 14 of the 2002 Act and all steps consequent thereto, including the order by which possession was directed to be given to a secured creditor. The dispossession of the petitioner was a mere consequence of the action and as such is also without the authority of law and has to be set aside. Hence, the secured creditor shall within 48 hours restore the possession of secured asset taken pursuant to the above mentioned application under section 14 to the petitioner. Entire application, all taken action taken thereupon, including all orders passed on the same by the Chief Judicial Magistrate, are hereby quashed and set aside as well. Nothing remains. Now, your Lordship will have a look at the appeal order and how kindly have a look at the order under appeal. I mean, the order.
My Lord, I'm sorry, my Lord. In the last occasion, I said it has been set aside. It was not set aside. Virtually, it has been entirely modified.
No, I'll place that. This intra-court appeal is directed against the order rated so-and-so. The appellants, being the respondents in the writ petition, are aggrieved by the directions issued by the learned single judge to restore possession of secured asset which has been taken by the appellants pursuant to an order passed under section 14 of the Act. The learned single bench has also restrained the petitioners from dealing with and or parting with possession of and or encumbering or transferring the secured asset. Learned Writ Court in paragraph 38 of the impugned order has observed that arguable questions have been raised by the writ petitioners and has opined that writ petitioners have to be heard, for which appellants respondents have to be filed affidavit in opposition within a time frame, and the matter has been directed to be listed in the combined monthly list of October 2023. Learned Writ Court, please mark this note. Learned Writ Court has also left the question of maintainability of the writ petition of the at the time to be open to be argued at the time of final hearing of the writ petition. It is the submission of the appellants that when the appellants had raised the issue regarding the maintainability of the writ petition, the same is required to be decided in the interregnum and to restore the possession of the property, possession of which has been taken by the appellants, which tantamount to granting the main relief in the writ petition and interlocutory stage. Considering the fact that Learned Writ Court has already observed that arguable points have been raised by the writ petitioners and has also noted the issue regarding maintainability of the writ petition, we are of the view that ends of justice would be met if the writ petition is disposed of at the earliest. Therefore, we direct the appellants to file their affidavit in opposition, reply if any so-and-so. We request the learned single bench to take up the matter for consideration commencing 18 September till the time the writ petition is decided. The status quo passed on so-and-so which is prevailing as on date will prevail. the learned advocate appearing for respondent submit that on account of appellants having taken physical possession of the secured asset, the respondent writ petitioners have no access to certain immovable articles which are not subject matter of hypothecation, and request that such article may be permitted to remove by the respondent writ petitioners. Learned advocate appearing does not oppose. So that order is not touched. Two aspects I'd like to beseech your lordship to consider. One is where the action is wholly without jurisdiction, it is devoid of any merit, it is void in law, and the fact that it is without jurisdiction is something that I can set up in any court, even in corollary proceedings. And if I can show to your lordship factually, this same bank, because your lordship will find the name of the appellant here, Aditya Birla Finance Limited, this is the private respondent here, and made the same mistake, that possibly cannot be countenanced in law, because they are, this order is of 2023. The bank is aware that such an action is devoid of any jurisdiction. So it is wholly without jurisdiction when the Section 14 authority appoints somebody to do something which is not competent to do. And the other coordinate bench judgment which is not interfered with, your lordship has taken a note of that. It is with regard to the aspect of who can be or is an authorized officer. So the folly, legal folly is when I'm making the application under Section 14, that itself is bad. Because it is the authorized officer who approaches the authority under the Act. And paragraph 28 considers that untouched by the division bench, holds that this application itself and naturally the consequential steps are all devoid of any jurisdiction. I will be able to show, and I'll show that not in 2 minutes, that what has happened is identical to what the situation here, just by name. 2 pages, if your lordship bears with me. One was the regional manager. One was the regional legal manager, and the other is the junior legal counsel.
Why are you not there before the tribunal, and why are you here?
Because your lordships have already held in a writ petition that such an action is devoid of jurisdiction. But if it is not under the Act, then the remedy under the Act doesn't apply.
The order passed by this court can certainly be taken care of and note of by the tribunal. It's not that the tribunal is going to ignore the order passed by the high courts. It can never be. So why are you here and not there?
I'll tell you, lordship. In one of the other matters also, I have successfully been able to, favorably been able to argue that before this honorable court, that where the Act doesn't, whether the authority or the steps taken under the Act is without jurisdiction, then I need not go under that Act to challenge the jurisdictional error. Your lordships have always interfered in matters which are ex facie without jurisdiction. In fact, those are the one of the 4 ingredients where a writ is maintainable without insisting on availing alternative remedy. My lord, this
is not an alternative remedy. This is the only remedy that is there in the Act.
The power that your lordship has is the only power under the basic structure of the Constitution.
Yes.
Every other statutory remedy is an alternative remedy to the writ court powers. And consistently, your lordship's view has been that if it has been without jurisdiction, which is why the coordinate bench judgment is actually not interfered with by the division bench.
No, but then this issue was never raised also.
Yes, your lordship has noted. Maintainability was raised. Your lordship kindly comes back to the division bench order. The division bench also does not interfere. Says, so there was a point of maintainability. I'll just place one paragraph. Kindly have a look at paragraph 2.
Of the division bench judgment.
Of the division bench judgment.
The court has also left that issue open. So it's open. The court has not yet decided.
Also left the question of maintainability. It is the submission of the appellants that when the appellants had raised the issue regarding the maintainability of the writ petition, the same is required to be decided, and the interregnum to restore possession of property, possession of which has been taken by the appellants, is tantamount to granting main relief. This was not accepted by the division bench, and I'll tell you, lordship, why. because of the Tayab Bhai judgment. That mere issue raised of jurisdiction does not denude the court of its powers to grant interim relief. And here, my lord, I'm on a much better footing. Factually, if I can show that two legal counsels went who could not have been authorized officer, then the genesis of the action is without any authority of law. It is not an order passed under section 14, warranting me to go under 17. Which is what the learned single judge has held, the coordinate bench has held, that the initiation of the action itself is incorrect. So if it is...
Show me the application
Yes,
under section
kindly
14.
have a look at just 2 pages I'll show. Kindly have a look at page 116.
Single bench judgment.
Yes.
116, your worship will find at the first supplementary affidavit filed on behalf of the petitioner applicant above named. This is before the additional chief judicial magistrate, Aditya Birla Finance versus me. I, Shubham Singh, disregards everything else. And at the bottom, your lordship will see Shubham Singh, authorized officer. This is one. Kindly have a look at 181. Serial number 63 at page 181. At the top right hand corner, your lordship will find Aditya Birla Capital. Serial number 63, Shubham Singh, Junior Counsel, Legal. So he cannot be an authorized officer. He is making the application. The supplementary affidavit he is filing. One more, I'll just show me and I'll stop. Page 127, your lordship will see. 127. Oh, that's not Shubham. Sorry, this is also Shubham Singh because 139, your lordship will turn over. Sorry, my lord. 139. That's not day. 139 is who has gone to take possession. So the authorized officer and this again, sorry, at 139 bottom, Shubham Singh goes out of employment to Aditya Birla. Gautam Das is the authorized officer. Aditya Birla Finance Capital, right hand top corner or left. And possession notice is being taken. Possession notice. Page. Kindly have a look at page 187. Serial number 43. 46.
181 was one
Shubham
Singh.
To show that he was the authorized officer who makes the application. Now I'm showing who has gone to take possession. That is that page. Read with page 187. Serial number 46. Gautam Das, Regional Legal Manager. Now your lordship will kindly have a look at 2A of the rules. I don't need to trouble your lordship with the rules. I'm at an ad interim stage. And ad interim stage, I'm prima facie showing that one junior legal counsel has discharged the functions of an authorized officer and invoked the jurisdiction under section 14. This honorable court has held to be completely without jurisdiction at all because 2A defines who can be an authorized officer.
Yes.
Prima facie, if I can show to your lordship, the interim order that I seek today is I can't ask for restoration of possession. I'm aware of that. They will be entitled to file an affidavit to show who was he, what they did. In terms of the division bench order and the coordinate bench order, let there be a status quo with regard to the possession of the property as on today, my lord. And your lordship will kindly direct or allow me to take whatever is inside that away.
The movables.
The movables. What is not hypothecated?
What is there? Documents.
There are documents. I am told there are some other
Computer or
there are air conditioners, furnitures, residential body, no? The residential flat, 2 flats, residential. One I used to stay, one my servants used to stay. So their stuff is also inside, my or whatever is inside. Those are not hypothecated. That with Mr. Bandopadhyay appearing, I don't think will be a problem. We can sit and identify what is hypothecated, rest I'll take out.
Inventory.
Nah, inventory only.
When was the possession taken?
Well, the possession was taken 13th of February 2025. No, 2024. And all this we got to know, Milord. When we filed the RTI application, when they approached there, did we come to know?
24 order measure 24 July.
Possession को नहीं होती. But January 2025, no? Physical possession was taken on 3rd of January 2025.
13th February is a symbolic possession.
Symbolic possession, 3rd January, symbolic possession not for 3rd January 2025 is the date when they take possession in terms of the section 14 order. And 19th of February 2025, I get to know of all of this.
Why from 3rd January? What were you doing? Physical possession has been taken. Were you not there?
Yes, I was there.
Then
I
how?
challenged it. It is only in February that I got to know that Shubham Singh and Gautam Das are actually regional legal counsels. And they could not have been authorized officers. And Milord, it's still a quasi-time action because they have not done anything with regard to that. Had I come in February also, I would have had to seek a restoration of possession.
How much is the due amount?
What is the due amount? That I'll just check. There are other, the credit facility was of 65 lakh.
Cash credit account or something?
7 crores 88 lakhs.
And there was more loan.
7 crores 88 lakhs 20.
But there are other
20
other properties.
657.
There are other properties which are high mortgage with them. They go to take possession only through these legal counsels. Now after this matter, I don't know what they'll do. Because after Justice Bhattacharya's order also, they do the same thing.
Other properties which are mortgaged.
Well, a financial creditor also has certain obligations to at least adhere to the law.
How much is the due in respect of the property where possession has been taken?
That there would be a bunch of cluster of properties given as security against the loan. So there are other properties also which are there because he's applied before the Kolkata Metropolitan Magistrate to seek possession. And they would not have given me the loan unless they were secured. But the point is, how do you enforce that security? You'll still have to follow the law. And after this Honorable Court holds...
What is your submission? Maintainability issue is already there.
One thing, you will kindly take the Honorable Justice Bhattacharya's order, first the single judge which he is relying on.
Yes.
Kindly take paragraphs, page 10. Paragraph 34 onwards, hence the security, the learned single judge has virtually disposed of to that extent because he quashed the order under section 14 and directed for restoration of possession. Kindly take restore first, then the entire application under section 14 of 2002 Act and all actions taken there, including the orders passed on the same by the Chief Judicial Magistrate, are hereby quashed and set aside as well. These are the final release granted. However, nothing in this section shall prevent the security creditor to take further steps and fresh steps in accordance with law. No maintainability point was kept open. Only affidavit directions were present. What
but then the division bench has kept
division bench virtually altered everything because the possession was already taken. It was kept with the appellant, that is the financial company, and the affidavit directions are given, keeping the point of maintainability open.
Yes,
now, in the present case, what happened? This order was under section 14 was passed. It was challenged before the DRT under section 17. They were unsuccessful before the DRT. After becoming unsuccessful, they came and filed these writ petitions. My lord, whether that can be agitated, first issue. The second issue is, my lord, the writ petition so far as these financial
Tell
institutions.
me one thing. Are you all sending legal counsels as authorized
My lord, there are two
representatives?
things, my lord, that is also a misrepresentation, my lord, made by the, kindly take this, my lord, act. I'll
Yes.
just, Your Lordship has the
Surfacey?
surfacing.
Yes.
Well, these kindly take the security interest rules. Well, first, I'll not take much time. My lord, that is
2A.
তারা আমাকে রুলসটা বের করতে দে। The security interest enforcement rules. Has your lordship got it?
Yes.
Now kindly take the first in exercise of powers.
Yes.
Right, in exercise of powers conferred by subsection 1 and clause B of subsection 2 of section 38, read with, well, kindly take note of these subsections 4, 10, 12 of section 13 of the Securitization, because the central government hereby makes the rules, namely, now authorized officer is defined in 2A. Authorized officer has not been defined under the Act. It is defined under the security interest rules. Now kindly take, my lord, section 13. Kindly come back to section 13. Under the Act. Act
Okay.
Kindly take section 13. 13, 12.
Yes.
My lord, irrespective of approaching section 14, my lord, before the magistrate, the security creditor has the right to take possession. Now, for that purpose, who is to take possession? My lord, 13, 12. The rights of a security creditor under this act may be exercised by one or more of his officers authorized in this behalf in such manner as may be prescribed. But kindly take, my lord, 13, 4. In case of 13.4, in case of borrower fails to discharge his liability in full within the period specified in subsection, the security creditor may take recourse to one or more following take possessions of the secured assets of the borrower, including the right to transfer by way of lease, assignment, sale for realizing the secured asset. Pausing here. But the secured creditor himself had the authority to take possessions. But when he acts, my lord, and take possessions himself, my lord, he should be authorized officer as defined under the rules. But so far as the section 14 is concerned, kindly take section 14 once. Where the possession of a secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred of the secured creditor under the provision, the secured creditor may, for the purpose of taking possession and control of any such secured, request in writing the chief metropolitan magistrate or district magistrate within whose jurisdiction any such secured assets or other documents relating to may be situated or found, to take possession thereof, and the chief metropolitan magistrate, as the case may be, the district magistrate shall, on such request being made, take possession of such secured assets and documents relating thereto, and forward such assets and documents to the secured creditor, provided that any applications of the secured creditor shall be accompanied by by an affidavit affirmed by the authorized officer of the secured creditor, declaring that these authorized officers have nothing to do with the security interest rules. It has been held by the Supreme Court also. It's no longer res integrata. Kindly takes one judgment and of the
Right now, we are at the interim order stage.
This has been held.
Right. 1 minute.
Section 14 court, two things. One is this order was challenged. They did not take this point, and I don't know whether they had taken that point. It was rejected. So they have opted out. They are opted the remedy. They had the opportunity to take this point. So to that extent, it is barred by res judicata. But so far as the second issue is concerned, 2022 5 SCC I have relied on, that against the Aditya Birla Finance, no deed is maintainable. The third issue is that this issue of authorized officer has been already long settled, and the judgment of the learned single judge is no longer, this is an interim order now.
Yes, yes.
It is not binding upon your lordship. So now they cannot agitate this point at this stage. Just refer.
Tell me one thing, the property that you have taken from him, possession you have taken, what have you done with it? Have you sold it
with
off?
us, with them also.
Not yet sold.
Not yet sold.
All right. You please maintain status quo. Let us see what can be done. Ashwin,
Malad, kindly first, Malad, kindly take this
I'll keep
judgment
all
once, Malad.
issues open. It has to be heard. I'll keep all issues open. Just you have not taken steps to sell it off as of now. You took possession
Yes,
in
yes.
January. We are in
Malad,
July.
I don't have instruction.
Not
Let her take instruction, Malad.
Acha,
Let her take instruction.
The issue involved in the instant writ petition is required to be decided.
হ্যাঁ বলে দিচ্ছি তারা আমি আমার judgment গুলো করতে
The petitioner has raised the petitioner questions the jurisdiction of the authorized officer who took steps under section 14 of the SARFAESI Act.
Yeah,
Stop. Writ jurisdiction has been invoked on the ground that the officer who acted, who allegedly acted in accordance with section 14 of the Act, did not have the authority to take steps in the matter. Stop. Next. Upon hearing the parties, it appears that that physical possession of the secured asset has been taken in the month of January 2025, and custody of the same is still with the finance company. Stop.
Before justice passes, kindly take this paragraph 35 of the Malad 2013 9 SCC, Standard Chartered Bank versus Noble Kumar.
Yes.
Kindly take Malad section 30. আরে একটাই কপি আছে তো দেখছি তাই জন্য তো আছে তো
They have a copy of what?
Yes, standard এই তো 13 SCC দে এই যে কি
13 9 SCC, find it out from the internet. 620.
Paragraph 35, Malad, kindly take one. There are other paragraphs also. Paragraph 35 is on that. So far as this Malad security interest.
Please read. You have a copy? Read out. No justification for the conclusion that the receiver appointed by the magistrate is also required to follow Rule 8.
35, kindly.
Procedure to be followed by the receiver is otherwise regulated. There, a receiver was appointed by the magistrate. Here, nothing of this sort has been done.
That is the authorized officer to be appointed by the magistrate. Nothing to do with the secured creditor. That is the section 14. Only
here, no authorized officer has been appointed by the magistrate.
Yes, he took positions, not our authorized officer.
The coordinate bench judgment.
I have to see. I cannot.
The affidavit being filed by the authorized officer.
35.
Yes, 35.
Yes, kindly take one magistrate.
The procedure to be followed is otherwise regulated. Rule 8 provides for the procedure.
Paragraph 33.
Then I have to see what is there. 35, 33.
Just and therefore there is
Specific
no
provision
justification for
is-
the conclusion that receiver appointed by the magistrate is also required to follow Rule 8 of the security interest rule. The procedure to be followed is otherwise regulated by law. Rule 8 provides for procedure to be followed by secured creditor taking possessions of the secured assets without the intervention of the court. Such a process was unknown prior to SARFAESI. So specific provisions is made under Rule 8 to ensure transparency. We do not see any conflict between different procedures prescribed by law for taking possession of the security. The finding of the High Court, in our view, is unsustainable. But the High Court might hold that this to be followed under Section 14, paragraph 36.2. Paragraph 36.2. 36.2.
Secured creditor has not gone to possession. He's gone through the district magistrate by filing an affidavit.
36.2. Paragraph 36.
He's gone through an affidavit filed by somebody who can't be an authorized officer.
36.2. Yes, 36.2.
The second situation will have where the secured creditor meets with resistance from the borrower after the notice under Rule 8.1 is given. In that case, he will take recourse to mechanism provided under Section 14 of the Act. Making application, the magistrate will scrutinize the application as provided.
This is what I'm on.
Then, if satisfied, appoint an officer subordinate to him as provided under Section 14(1)(a) to take possession of the assets or document. For that purpose, magistrate may authorize the officer concerned to use such force as may be necessary. After this possession taken, these assets and documents will be forwarded to the secured creditor. The magistrate appoints the officers, my lord, to take possessions. My lord, that officers nothing to do with my lord, security interest rules. And so,
No, the officer who was appointed is a legal counsel of the
no,
case.
no,
He
that
directs
is
the authorized.
Wait,
No, Shagoda,
that
factually, he
was,
direct-
my lord, he is saying that the application which was filed before the magistrate, that was by the officer authorized by the secured creditor.
So he can't be the authorized officer. That's the issue. He can't be the authorized officer.
And 36.4, my lord, my junior, the same thing. This nothing to do with my lord, security interest rules.
To allow the court to decide the issue. The parties are directed to maintain status quo in respect of the subject property. Stop. Let the matter appear for hearing. No, you want to file your
I
opposition.
don't want it. It is on the
The
legal
point of
issue.
law, yes. Let the matter appear for hearing in the combined monthly list of August 2025.
Maybe must fixed because I am without the 7 crores has been taken away. They have
No,
not
the
returned
property is with you.
property, but
I
if
have
I am
paid
not
6.5 crores.
From
I am
6
unable to
from
sell it.
yeah, from July you are from January you are holding it. You have not sold it as of now.
What a good price. 1 month.
No, the price is not there.
6.5.
I need to sell it.
7.5 I paid.
I need to sell it.
Very well. If you
It in
think
the supplementary list because I am not using.
if you want to sell it off, you make an application. The court will certainly see what is to be done. As of now, status quo.
May I have access to the property to take back what is not hypothetical?
No, as of now, no, because the law doesn't permit.
Very good.
Yes.
Asking that let it be in the supplementary list. Any day, philosophy so chooses.
পিটিশনারের উকিল বাবুর নামের বানানটা যাতে ঠিক থাকে
Be a supplementary list.
It cannot be taken up in the supplementary list. I am taking up the monthly list as a supplementary list and trying to restrict as many matters in the supplementary list so that the monthly list can be taken up. Otherwise, it becomes a garage. Monthly list is never taken up.
It will appear as motion, no?
Motion.
Very
Though it's not a time for mentioning may secure lordship because of extreme urgency. Like, in terms of list, possibly item 26 will not be taken up. To 26 of today's list. Today, people from the bank has come and put a padlock on my premises. I have challenged the jurisdiction of the bank because it's not a secured credit. That's my challenge. My original deed is with me. I have never taken loan from the bank. My brother has taken loan. Deed is with me, but I have no nexus with the bank. My bank has put a padlock on me and issued a sell notice. That is my challenge. If it's a secured credit, then bank can always issue notice under section under the Act of 2002.
It will appear in the list tomorrow. Serve notice upon the other side. Item 26, urgent motion tomorrow.
Grateful. Record.
Yes.
I am for the petition. Lord, the private response. Direction to file a report today in the form of affidavit in respect of the matter where, in spite of death of the executor of a power of attorney, registration has been done by a registering authority without looking into the matter, divorce the statutory provision of section 32 to 36 of the Registration Act, read with section 7 of the Transfer of Property Act.
Affidavit be
Lord,
is the affidavit ready? Is the affidavit ready?
Lordship, my lord. The copy has been served. We have taken exception to that.
All right.
Lord, now I am placing the matter.
Served on us. I am the private respondent, and there is a judgment of the Honorable Supreme Court. I am citing it. I can cite it here and now, which says that the registration authority, even if there is an error in procedure, the registration authority does not have the power to recall a deed, and it has to be done by a civil court.
All right, you please.
This is
Lordship, my lord,
I know
the last occasion, my lord, Lordship's order, my lord, dated 14th May 2025, my lord. Lordship was, my lord, desired in para 3 that you are to give answer to these 3 queries. One is whether the subject deeds annexed to the writ petition description whereof is available in page 13 and 14 were either genuine or not. Secondly, whether they were registered relying upon any unregistered power of attorney. And thirdly, my lord, whether, my lord, the aforesaid HON'BLE Dash was one of the executants of the said power of attorney, my lord. My lord, may I respectfully invite your lordship, my lord, to the, my lord, report on affidavit filed by this ADSR of the concerned, my lord, jurisdiction, my lord. I find, my lord, in para 2, she says, what is a locus? There was no whole time this ADSR, so she is part-time and she is affirming this affidavit. My lord, may I respectfully invite your lordship to para 4, my lord.
Yes.
Kindly sees query number, respectful answer to the query of this honorable court is 1. Documents mentioned in 13 and 14 were registered in the office. So she says this. Second, respectful answer to the second query, whether relying upon any unregistered power of attorney, she says in the office of ADSR Chandanagar, the information related to the power of attorney number 59 dated 10th October 2017 is not available in the office record. As because, my lord, if your lordship kindly looks to the recital of all the deeds which my learned friend has annexed to the petition, there they have only used the sentence that 59 power of attorney mule ami mukhtar hishabe.
No, the details were there.
No. So that is why this deponent is giving this answer that POA 59, this reference she is getting from
Very
the
well,
side of
it's
the,
not there.
I don't get. It is not in our office record. Third, my lord, she says, after cross-checking the alleged documents in question, it is found that Sharnalata Dash was one of the executants of the power of attorney number 59 dated. This I find, my lord, this answer is somewhat ambiguous because if you say that power of attorney is not with you,
then how could you
how do you say that HON'BLE is one of the executants? This, my lord, I need some clarification. How does she say this on oath?
Right.
Kindly give me, may I come back with a short, my lord, supplementary. Kindly give me 3 days, 4 days, I shall come back. I need, my lord, my learned friend has also taken this point in his exception.
Obviously, when
It
you
is
say the document is not available and you go on to say that he is one of the executants, where from did you get to know?
Well, yesterday night I talked
And
to the
that too on cross-checking the alleged document. How could you cross-check
Where do we
if the document
cross-check?
is not there?
My lord, kindly, my lord,
It is self-contradictory. My learned friend has taken this point.
I'm placing them, my lord, what happened? My lord, kindly come to page 68. Answer is there. They cannot say. And this is my lord, we made a complaint before the police station. Investigation done. Now, my lord, charge sheet. Kindly see the charge sheet, page 61. Now, 69, paragraph 4.
Yes.
Original power of attorney. My lord, got it. They have says this. Police. Now, my lord, kindly come to page 73.
This is a Caesar list or what?
Yeah, this is the charge sheet. Charge sheet oblique final report.
One
the police
original
investigation.
general power of attorney, such and such, containing
They have said the original. Now kindly come to page
such
73.
and such are found. That means the original is with the police right now.
Yes.
Also with one notarial certificate of such and such,
Yes.
containing one page.
Now page 73.
73.
73 and 74. After investigation, that particular power of attorney was sent to document verification department. They said this is the fake one, already decided by the question document department itself. And by virtue of that power of
Where
attorney,
is it? Where is it?
if, yes, page 73, 74.
73, which during the original power of attorney.
During investigation, then.
Alleged to be fake.
Then,
Alleged.
no.
And the
Thereafter,
copy?
page 74.
All right. The specimen signature somewhere collected.
Report reveals that 74.
The specimen signature handwriting.
Sent to the question document department. Then.
For telling the signatures of the complainant,
Reveals the report.
The signatures of the power of attorney were
Signature
not
of
of
the
the
power of
complainant.
Turned out to be forged. So this is the
Ready.
question investigation.
And if that is there, by virtue of that power of attorney, along with the dead person, all things goes. My Honorable Supreme Court says, my lord's power up to what stage? Not to declare those deeds void. I shall go before the trial court for declaration of that. My lord, jurisdiction up to the stage that the act of the authority is non-est in the eye of law in view of section 32 to 36. Well, I am placing that judgment. If that is so,
I'll also place a judgment which says
all right,
the
I have
registering authority does not have quasi
In
judicial
the-
power and is a full bench of the
that act.
On the issue of dereliction of duty by the registering authority, which my learned friend for the petition is, I do also am fortified by two judgments of the Honorable Supreme Court. That will not, when the executant himself is presenting the document for registration, that power of attorney need not have to be registered document. That is one proposition. Second proposition, the word in section 32
That means with an unregistered power of attorney,
can be,
it can be
because
sold.
here, if your lordship sees, here the attorney himself has put his signature. So here,
Then I'll hear it out.
that is one.
Please come.
Lordship, that clarification part will not
report
kindly.
Only thing, let the
in the form of affidavit
because I'm the private respondent.
on behalf of the respondent number 4 and the exception thereto by
What I
the
have to
petitioner
explain.
filed in court today is taken on record.
Exception.
You have not received the writ petition.
I have not received either the report or the exception.
No, report is all right, but the you are representing 5 and 6.
Madam.
No, there are so many. Who are you representing?
I'm sorry, 6 to 12, 15 to 17, madam.
6 to 12
They are the alleged purchasers.
and 15 to 17. Wakalatnama filed?
No, it has been filed.
Yes.
It has been filed.
And you received a copy of the writ petition?
Only the writ petition, nothing else.
Nothing else means what else will you receive?
He wants all these reports and exceptions.
Because if allegations are put against me, my lord,
Yes.
He's not the
But
promoter.
then you were
Subject to-
not. Oh, you were there.
promoter.
Last occasion 6 to 12 and 15 to 70 was there.
subject to leave.
Yes, yes.
Report will be given unless leave is given.
No, very well. Report will be given. The matter is to be heard. Are they taking any steps in terms of the sale deed or whatever deed?
Yes, they are going to be acted upon. That is why I sought leave before your lordship for move the matter.
All right.
And I prayed for before your lordship that not to be given any effect to of subsequent any stage.
All right.
Now, my lord said, let the report comes. So I am praying for not to give any effect of those deeds, because in the meantime, if these deeds are being acted upon, then everything will be in a soup. Third party right will be created.
I can argue on merits
Action
before an
for
interim order. If my
annulling
lord is contemplating an interim
registration
order,
of
I can
sale
argue on merits.
and such and such. You are the purchaser. You are the purchaser.
And I am the purchaser today. Today, my lord, My lord, this is a ploy by which my title is being sought to be taken away without going to the civil court.
Are you the purchaser?
My lord.
All right. What is the property? It's a land or what?
Land.
What?
Land, my lord, land. It's a land. My lord.
It's a land.
My lord.
And what are you trying to do with it?
It's a residential house. I'm building a residential house.
You are in a residential house. You've purchased it already. Right.
These plots are land.
That is to be hard.
Vacant.
Stop. And the vacant land. It's a residential house.
No, I am in the process of building a residential house.
You are
in the process of building a residential.
So right now it is not a residential house.
Right now it is not a residential.
It's a vacant
Schedule of
land.
the property says so. Page 97.
Vacant land.
Vacant land.
Vacant land. I for my own residence. I want to build a house for my own residence.
All right. As of now, you've not done anything.
No, as of now, nothing.
The subject property is a vacant land. Stop.
Properties.
The nature
There are 10
of the
deeds.
properties.
In different deeds. Means my lord mentioned earlier order.
The parties are directed not to change the nature and character of the subject properties till 28th of November 2025 or until further order, whichever is earlier. Stop. Do you want to file an opposition?
But I would like to file an opposition, but the only thing, my lord, since a considerable amount of consideration has been paid from my hard-earned money, my lord, and now, my lord, without going into a civil court, when
the court is not deciding upon the title as of now. All right, so it is up to you.
But my lord, since my lord has
it will be open for the private respondents to file affidavit in opposition to the writ petition. Within a period of 6 weeks, reply, if any, within 2 weeks thereafter. Stop. Liberty to mention the matter for hearing before any other honorable bench having determination.
The only thing,
one prayer.
My lord, today I have spent a lot of my hard-earned money for buying.
But he's taking away your property.
But I can't even build a house on it, and
you cannot build a house that way. You have to obtain a sanction plan, and a lot of things are there.
Injuncted in terms of earlier order.
Please do not proceed anything. Let us see.
One addition.
I have kept in record. You do not change anything. I am not giving you leave because he has already taken that point. So you will be rectifying your defect, which the court is not permitting.
It can be heard out and disposed of any day subject to your
Yes, yes. It will be heard out. It will be heard out.
I can argue on merits.
Yes, yes. The court will hear you.
One,
the next matter.
One addition. I mean, not to transfer the property and third party right. In the meantime, if they sell,
but in that case,
no,
let third party rights.
Your title is in defect.
Third party rights not be created in the subject property, as the same will lead to future litigations.
I will kindly record my submission that I have taken the point of maintainability.
Okay.
Yes, the issue of maintainability raised by the learned advocate representing the private respondents is left open.
Grateful to us.
Miller, report is hereby served upon him, Lordship.
Yes.
But can it be fixed any date?
No, no. As of now, no date. Try out. There are other benches hearing. Please try out over there.
Also some matters.
Very rare. See the motion pressure.
It was a joint prayer. If
it can be
done.
It can be done. Prayer jointly for fixing any date.
No, no, fixing a date is not possible.
Grateful.
Okay, the exception to the
Well, there is some development which I just apprise your lordship. This is a matter relating to seeking information under Right to Information Act. And my lord, I would also humbly submit that this writ petition is in the essence of, because my prayers indicate, access of public documents that relates to me.
This is the main point involved in this writ petition. I was transferred from this new secretariat building to Alipurduar. I approached the division bench of this honorable court. This honorable court directed an order of stay and sent it back to the tribunal, state administrative tribunal. The matter was heard before the state administrative tribunal and my original application was rejected. Thereafter, my lord, I again approached the honorable division bench. Again, the honorable division bench, my lord, set aside the order of the tribunal and has categorically observed that there has been violation of the previous High Court order and send it back to the tribunal with an observation that the next release order which has been given, the department will not insist upon it till such time I file it and the matter is heard out and heard out on merits. My lord, the division bench order ta this is the
Then what has happened?
now
You want certain information. The authority has been directed to
information is there.
provide the information.
My lord, one more thing, my lord.
Is the information there? Give it to him.
5% short what?
All right, pass it
No,
on
no.
to him. The court does not want the information. It is for the petitioner to be informed.
No, my lord, that is not the information which I have been sought for.
Have you been given any information?
No, not yet, my lord.
No, what
I have
what are another Atia, what are it must pay for a specific information. Third party information we cannot supply.
no, my lord, it is not a third party information.
No, what a Shishendu Sarangi is a third person.
No, no, no.
Siddhas Ganguly is a third person. Srira Kasna Datto has been transferred. And
No, my lord, all these informations I don't want.
These are all official records.
My lord, I have prayed, my lord.
According to kindly see paragraph 11 of my lord's order was
Yes.
directed to ask me to supply the authority is liable to then my lord 12 the transfer
Where is the transfer policy?
according to instruction received from me that's why there is no transfer policy for the industrial development officers of the directorate of small scale enterprises MSCB government of
That means there is no provision to transfer. If that be so, then how are you transferring?
for the industrial development officers of the directorate is under process. Under process.
That means as on date, there is no transfer policy.
However, the first posting of industrial development at an entry level, next posting and the transfer process to IDO as a group B employee is considered under following criteria.
As on date, there is no transfer policy.
But we are maintaining certain first 65% direct recruitment, 35% by promotion from on compulsory appointments, etc. Then those who are appointed on compulsion ground or this ex-servicemen, they normally try to retain in the government because
No. This person was working here. You have transferred him elsewhere.
Working in 11 years in Calcutta.
11 years, 21 years, 31 years, you do not have a transfer policy.
Yes, but we are transferred about 5% more than 200 kilometers. Out of
If those persons were agreeable to the transfer, there is no problem. But this person,
kindly see for a moment, just
I do not want to see anything. You make submission, I will hear you.
Yeah,
You
kindly see this. Vacancy position of the industrial development officer at different district industry center or official block development officer in different district of the state or at zonal officer at the director headquarters. B. Duration of service at the existing place of posting, distance from the place of posting of spouse if she is an employee under the government of West Bengal, children, boards, final exemption, secondary, higher secondary, etc. Students stayed along with the employee place of resting.
How are you all doing all these things?
Maintaining this at the present moment until the transport policy is formulated, we are following this.
There must be a principle. You cannot follow things here and there. There has to be a principle.
We are following at the present moment till the finalization of the transport policy. Just somebody appearing in a class 10, 9, 10, 11, 12, yes, they are considered. Then
forget class 10, 12. This is a government service. They are government employees. Their service regulations are codified.
Yeah.
If you are to transfer somebody, if somebody opts voluntarily Post me somewhere, and if there is a provision, you do it. That is different.
Government officers, there is no voluntary transfer. Only transfer, all post appointments are transferable all over West Bengal.
Show me your transfer policy.
I've said so. This is our guidelines we are following.
Who is instructing from behind? Who is the person? Who is the person? Who are you?
I am working in MSME department.
Who do you hold any?
Joint director.
You are the joint director. Your learned advocate is here making submission. Why are you prompting from behind? Please take a seat, or you can leave. In case you feel you are very excited to make submission, then you may leave, or please take a seat. Do not open your mouth when your counsel is here. All right.
But according to paragraph 12 of my Lord's order, the transfer policy of the industrial development officer of the directorate of MSc, the number of employees transferred from the external department headquarters to other department more than may be from the permanent residence address of the release the matter on 2nd July 2020. This is the direction. So far, 200 kilometers posting is concerned, but we have transferred about 5 persons out.
Why? How many employees do you have in your department?
That is why, my lord, I wanted to inspect the entire file.
Yes.
645.
645. Now you have transferred only 5 out of 645.
No, 218 persons are in a permanent post.
200 out of 218, 5 have been transferred. Five out of 218. How could you select this 5? What is the mode of selection?
That will be decided by the nature of the work and involvement. That will be
So everything is vacillatory.
No.
There is nothing codified.
That will be decided by the administration, not by us. This will be decided by the administration, considering all these aspects. If there is a candidate for appearing in the exemption, or husband and wife working in the same place, or whether there is a
yes, that means husband and wife working in the same place, a request will come to you, you will consider.
Yeah.
So that is a voluntary opting of transfer.
When somebody who wants to transfer somebody else, then if we got an information that his son or daughter is appearing in Madhyamik exemption.
That is the willingness of the person to get transferred.
No, but when we are going to transfer, if somebody makes a representation that...
Mr. Please, sir, please try to follow what is the query of the court. How do you select persons to be transferred? Where is your policy?
So far from the home district, from 200 kilometers,
200 you forget, even if it is 20 kilometers, how do you transfer? How do you transfer?
But that your lordship will see. Your lordship wanted to know what is the transfer from settlement headquarters to other restaurant more than 200 kilometers away. This is the question.
Court wants to know what is your transfer policy. Thereafter, the kilometer will come. Show me the transfer policy. You do not have anything.
According to written instructions, there is no transfer policy. But
right. It is in the process of being formulated. It is all right.
But we are practicing some practice.
What is the practice that you are following?
5 guidelines have been.
Yes,
following.
please. Please show.
Instead of reading,
such a voluminous for 5 lines.
Not only for first page.
You read out. You tell me what are the points that you follow.
All transfer orders.
I do not want the transfer order. The court doesn't want to see who you have transferred.
Kindly go through.
You tell me what are the. You read out.
The vacancy position of the industrial development officer IDU at different district industry center, EIC, sub DIC, or office of the block development officers in different district, state or zonal officer, or the director headquarters. Duration of service at the existing place of posting. One of the questions. Distance from the place of posting of the spouse, if he is an employee of the Government of West Bengal. Children's board final exemption, secondary, higher secondary, etc. If the student stays along with other employees at his place of posting. Interest of the public service, very important. And service delivery of the general public all over West Bengal, including remotest part of the state. The number of employees transferred from the directorate headquarters of other departments under director of MC more than 200 kilometers from the permanent resident at 5 below. One Seaksungsho industrial headquarters, Calcutta, transferred to Barjora. Then Madam Seaksho Ganguly.
No, don't name anybody. The court is not concerned with the name of any person.
Madam, then Sudipta Chanda, petitioner, he was posted at industrial headquarters, has been transferred to Kalchuri on 7th of May 2025.
Yes. Now, how do you select a person for being transferred?
But can it be gone into the question by the court? But I'm putting the
How
question.
do you select?
No. But that is for the administration.
That means the moment you see that somebody is not in favor of the government, you select him and you transfer him. This is what you've done.
But that is not for the adjudication by the lead court or the Article 26, because that would be the service jurisprudence.
Yes.
But can you see, in connection with the affairs of the state.
Yes.
Under the administrative tribunal act,
Right.
the affairs of the state.
Yes.
Jurisdiction of the tribunal
Right.
High Court has been curtailed by
Very well. Please come.
And can you see the
Kindly allow me to inspect the documents, my lord, of my transfer related files that I have prayed for specifically in my right to information.
What prompted you to transfer the petitioner? Is it only for the service purpose?
Service
for
purpose,
the
for the interest of public.
The private responsibility is also working for 15 years.
No, he is working more than 11 years here in Calcutta.
Private respondent is also working same place for 15 years.
Transfer that could be decided by the court or by the administration.
Let me access my entire transfer related files.
It is
the entire file,
all
the
three
note
of them
sheets.
done.
That is why I wanted to access the
If
entire.
somebody to stay in Calcutta and
So this is not a this is
no,
the
I'm not
court
going
where
to
transfer is adjudicated. I am
accept
just
the
saying,
public
my lord, entire public document relating to my transfer.
whether he will go, whether he will not go, it is his matter. The competent forum is there to adjudicate.
Yeah,
This
that's
court
what-
is not adjudicating
Already stayed by the High Court.
whether the person is going, not going. Right?
Get food or
The court only wants to know whether you have a transfer policy in place or not,
I've said
which
so.
you do not have.
Then I have,
This is
but-
what
But we are following certain
you
guidelines.
are following your own dictum to select people according to your choice. Who you do not choose to stay over here, you will send them somewhere else.
We have
This is what you are
five
doing.
guidelines are there. We have
Yes,
the 5 guidelines.
guidelines are meant to be followed equally for all persons. You do not do that.
Not that
Out of 200 something, you select 5
Yeah.
and send. Please come.
And all are within transfer.
Note,
Uh,
my lord, kindly be allowed.
Not,
My
no,
lord,
is not
my
a
lord, yes, my lord. My lord.
evidence.
No, it is, my lord. Under section 75, public
The-
documents I can access.
Learned Senior Counsel representing the state respondents has received instruction from the department and placed the same before the court. Stop. It has been specifically submitted that there is no transfer policy in place in the subject department. The department follows certain guidelines. Stop. Next. The petitioner intends to
Right to information query number 5,
yes.
page 19A, type copy. Please provide me note sheet of pages containing when processing and decision of posting of industrial development officers arriving to the order numbers. These are transfer order. 19A. Well, it is very urgent.
Note sheet cannot
And
be
the
given
transfer policy.
under any law.
My lord, yes, note sheet can.
No.
My lord, their
But they
answer
will-
is that it affects the integrity of the government. I put a question to myself, my lord, what integrity will go? This is a personal file of transfer.
Of the Evidence Act.
Now, section 75 of the 75 of the Evidence Act, my lord, categorically says.
Would you like the information that has been produced in court today? You please pass it on, whatever information you got, so that the petitioner gets to know. The information that has been produced in court today has been handed over to the learned advocate for the petitioner for perusal. Stop. Release the matter for further consideration. Next week, I'll keep it. In the meantime, you go through it, whatever is there.
Yes, my lord.
Today is second, on the 9th, next Wednesday.
Madam, may I request my learned friend to join in the place of posting, otherwise.
This could you make this state.
I do not have the jurisdiction to guide or advise or pass order.
Kindly record my learned
can-
friend is insisting on.
I can
Kindly
do that.
record my learned senior friend is insisting on. There is a stay by the division.
Item number 13.
This is my application, my lord.
Who is for the petitioner?
I am for the petitioner, my lord.
Yes, please.
Now the case is that, my lord, the petitioner at the, my lord, commissioning couple, my lord, intends
40 years, 60 years.
Yes, my lord.
Yes. Why
My
don't you
lord,
go for adoption?
my lord, I have taken instruction, my lord. My lord, so far my instruction is concerned, my lord, there will be no biological connection in between the parents and the child.
Obviously, there will not be any biological connection, but then
And
you
that's
have,
why, my lord, the petitioner wants to avail the, my lord, the
you have failed to
natural
get it naturally, right? So you have to depend upon
this process.
outsourcing.
This process. Yes, my lord.
So this matter, it can always be given to a commissioning couple. It is not so.
My lord, but in a similar circumstances, your lordship grant permission to the other petitioner, my lord.
Yes.
Now, my lord, this is a personal liberty. Your lordship knows, my lord.
No personal liberty. There is no personal liberty involved over here.
My lord, I have covered by the this right by the apex court judgment, my lord. If your lordship kindly see.
Is it under this provision?
No, this.
Then why are you relying
but
upon?
the particular things, my lord, the point, my lord, covered by this judgment, my lord.
Which point?
My lord, the
To get a child.
Get a child, my lord.
Yes.
Is, my lord, covered under, my lord, personal liberty under Article 21 Constitution.
Yes.
The state cannot interfere into the personal liberty.
Right.
That point, my lord.
So you go get a child who the state is not interfering.
But the, my lord, I am, my lord, the petitioner number 1, who is, my lord, under the statutory age, but denied. And on the same point, my lord, your lordship passed the order, and my lord granted permission to the other petitioner.
Yes, there were
And I am
factors.
covered by the, my lord.
There were factors. What does the petitioner number 2 do?
My lord, he is a retired, my lord, teacher. Now, my lord, he is getting pension, and my lord, providing private tuition.
Providing
well.
private. And what does the woman do?
Woman is a, my lord, housewife.
The judgment that you are referring to by this bench has taken into consideration a lot of factors. Right?
Yes.
Here, those factors are not known to the court also.
The petitioners, my lord, as per, my lord, the direction of the, my lord, medical expert, my lord, they have produced all, my lord, the medical documents, my lord, and that revealed, my lord, that they are fit. And I have served, my lord, the respondent number 4, which is the institution, my lord, recognized under the state, my lord. And they stated, my lord, the until and unless they get the court direction.
Not do. Somebody will advise you and the court will pass an order. It is
No,
not.
that is, my lord.
It can never be so.
My lord.
The court will pass order only if the
Yes, my lord.
facts and circumstances
my lord.
Permit.
My lord. Now, kindly see my representation.
Where is the financial condition of
My
the husband?
I have annexed, my lord. That's the page 51. 2, my lord. Page 55. It means, my lord, if my lord, your lordship direct me, I can produce, my lord, the income status of the husband, my lord, by giving affidavit, my lord.
Have you annexed the judgment of this bench over
Yes,
here?
yes, my lord, my lord. I have annexed, my
Oh,
lord.
page
It's
71.
page, my lord, 71.
Please come.
Your lordship
It's
also
up-
referred this, my lord, the judgment I have handed over, my lord.
My lord.
Please come. The petitioner number 1 the petitioners are a married couple who unfortunately lost their only child of 17 years.
My lord, it's 18 years as per death certificate.
18 years. 18 years. You have mentioned 17.
That is typographical mistake, my lord. May I apologize?
Only child of 18 years. Currently, the petitioner number 1/wife is aged about 49 years, and the petitioner number 2/husband is aged about 60 years. He must be over 60 because he has retired. When did he retire?
He's
Last
my
date
lord.
of the 24. That means he's crossed 60
21.
years. Is just above 60 years.
21 years.
ঠিক আছে? They intend to get a child once again. Stop. The petitioners would like to avail the facility under the assisted reproductive technology within bracket regulation bracket close act 2021. Stop. As the petitioner number 1 is overaged, petitioner number 2 is overaged, comma, the medical clinic is not permitting the petitioners to avail the said facility. Stop. The petitioner relies on the judgment delivered by this bench on 22nd November 2024 in WPA 23776 of 2024 within bracket Shamuli Shaha and another page 71. Check the spelling.
And my lord, the Supreme Court judge.
Another versus State of West Bengal and others. Wherein under similar circumstances, the court permitted the commissioning couple to be provided the benefit under the act. Stop paragraph. As similar relief has been granted in the matter of Shamoli Shaha within bracket Supra, accordingly, the court passes similar direction herein. Stop. The respondent number 4 clinic nursing home is directed to permit the petitioners to avail the facility under the act. Read petition stands disposed of. Service is taken on record. Take back the Supreme Court judgment.
Yes. Grateful to.
But after the respondent, yesterday these matters, two matters were got dismissed for default.
Yes, thereafter, was it intimated to you? It was recalled, was it intimated to you?
I followed the list today.
No, but then there was a deduction for providing intimation.
Anyway, my lord, they have
What is it?
Lordship, 600 and 601. Kindly not today.
Again, not today.
Kindly not today.
Mr. Shawanta was here just now.
601 yesterday was dismissed for default.
Right.
Nobody appeared. I'm appearing for SEBI in the matter.
Yes, there was a direction upon the petitioner to. Where is Mr. Shamanto?
He is engaged code number 42.
Lord, no intimation was also given to us, Lord.
There was a specific direction to intimate the other side. See, this is how it is being practiced. Please come.
Well, the other matter, there is a tag matter also, WPA 19383. That has been posted in the monthly list of July yesterday.
Yes. Acha. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. List in the monthly list of July. Record appearance of the respondents. 600 and 601.
Well, these two should be along with WPA 19383.
That is appearing in July.
That should.
Yes.
If appears together, then it will be.
Let it appear. You
Then
mentioned.
we'll mention the serial numbers. Yes, yes. That can be. At the time of taking up one matter, we can mention the serial numbers. Yes, ma'am.
Yes, call the next one.
Deeply obliged.
651, I am appearing on behalf of the petitioner, my lord.
Yes.
What I am seeking, my lord, that is removal of some illegal occupants. They are occupying 5 number of flats. Those flats actually belong to the government of West Bengal Housing Department. Those were allotted, leased out to me. I am a public limited company manufacturing clinical and industrial oxygen. We have another manufacturing unit in Kollani for accommodating my employees. Long back, these flats were leased out to me. I'm still paying rents, but these are 5 ex-employees. They have already superannuated. They are staying
Whose
there.
employees are they? Your employees?
My employee. They were. They were.
They were your employees.
Employees.
Now you are unable to remove them from the flats. And now you have filed a petition.
I have paid all the rents. Kindly see my representation, my lord. It is at page number 54.
The persons who are in unauthorized occupation were your employees.
Yes, your lordship. But now they are not staying there. Their family members are staying there. They are already retired. Some of them died also, my lord. There are 8 numbers of flats are there. In 5, they are staying.
Yes. Housing
I
board.
served them, but
Housing board.
No, my lord, housing board has been made a party, but there is no reliefs claimed against housing board. There is nothing to do
I'm
with housing board. But if
seeking
respond
consideration.
number 2 and 3.
Trying to sue them and
My lord,
evict them.
My lord, what they are trying to do, my lord, they are trying to establish title over these properties.
Why are you not
They have
approaching the civil court?
My lord, they have changed the electric meters in their names even.
Why are you not approaching the civil court? Why
kindly
the
comes to page
requirement
82
man?
once.
My lord, I'm saying, your lordship, my lord, I don't have the allotment papers. I have sought those allotment papers from the
That
housing
is your
department.
problem. The writ court,
They are
the writ
saying-
jurisdiction
They
will be
are saying
invoked.
that the allotment papers are lost just because they have moved the office for 3 times. My lord, kindly come to my representation, which is at page number 54.
There is a civil suit. Title.
Yes, yes, that's what I'm saying.
This
Page
may
84.
fall. It is page 88, my lord.
Whose order is this? Who is the plaintiff?
Yes, your lordship.
Who is the plaintiff? He is an ex-employee of the refund company. He is residing in the suit properties. The rent was from thereafter the British employer government to treat him as a tenant. Right. Because it... Yes, what is your representation?
Yes, it is at page number 54, my lord. It is to the estate manager and the subdivisional officer, my lord. your lordship pleases to send it for consideration, I think after giving a hearing, it would do, my lord.
No. It's an absolute private dispute between you and your ex-employee.
This is not a private dispute, my lord.
Please come. The petitioner.
May I,
Yes.
actually, there is an agreement.
Who are you?
I'm for the petition.
Yes.
There is an agreement in between the housing department and the company. Company, their productive, the production is that the oxygen and allied material.
Whatever is your, the court is not concerned whether you produce oxygen or nitrogen.
There is an agreement in between the housing department and the company. On the basis of that, they are collecting rent from us regularly. We are paying the rent even today also. The employees who are retired from the company, they are residing there. Some of them already expired, but we don't have any document regarding the expiry. But now the problem is that we don't have the copy of the agreement between the housing department and myself. And now the housing department on my RTI application, they said they also don't have that copy of the agreement. But that is the whole difficulty. If I have the copy of the agreement paper, then I can go for the suit for a suit and for eviction. That is absent. That is the total.
So you have to find out a way to solve it. But you cannot come up in a writ petition, seek for a mandamus for removing these people.
I am not seeking for mandamus for removing, but I am seeking for they have to initiate the proceeding under the
For what purpose?
For unauthorized occupants.
That they can do it suo moto if they feel.
They are not doing so. That is
there are so many government properties. You are not coming. You are coming here because you have a private interest over here.
Yes.
Isn't it? Then is it not a circuitous method to throw away the persons who are there, and those persons have already approached the civil court for relief?
That is this for default.
No, not dispute for default, my lord. Page 88 something. No, that is notice to show cause.
No. Page 88, kindly see.
Yes, page 88 দেখছি তো আমি।
Order number 7, kindly see the bottom.
Please come.
That is dismissed for default.
তারপর রেস্টোর হয়েছে কিনা কেউ
The petitioner number 1.
যেটা দেখিনি।
CO department,
claims to be a public limited company. What is the housing board doing?
But there is nothing to do with the housing board. This is between the housing department and the petitioner.
All right, it's the department. It's not your
Housing board.
It's the property is not within the board's jurisdiction.
No, my lord, no.
All right, then why has the board been made a party?
That is why I'm humbly praying for expunging the names of the respondent number 2 and 3, my lord.
The housing department is happy by getting the rent from the petitioners, and thereafter
done nothing.
Persons are not who are not authorized to stay are staying over there.
Kindly see.
You check up your records also.
Not sure. Kindly see page
The estate manager, my lord, has written
what
instruction.
instruction?
The instruction is something, my lord. So can you see this? He said that how I have been made party, and he has given me a notification by saying that I have nothing to do, and his prayer is basically to consider that representation.
In exercise the powers conferred in suppression of all other and STO, prescribe authority in the public premises. But then you will be representing the SDO also.
Yes.
District manager, another. Do you have anything to show that this the houses or the flats or whatever are they belong to the government?
Kindly see page 58 once.
Yes, you are paying rent.
This is 58, my lord. This is a letter from the the subdivisional officer Nodia, my lord, asking for the rent. This is the first.
STO Nodia is asking for rent from petitioner number 1.
Now kindly see page 64. Kindly see once page 64, my lord. This is a letter from the estate manager State directed, my lord, letter to the, my lord, the general manager of the company, my lord. The next page, my lord. He is also asking for the rent. And pursuant to that matter, I deposited the money, page 66. There is a
Suppose it's a government property, then is this property only meant for the employees of the company?
no, it's first one is allotted to the company. My lord, company made an application for allotment some waters
Yes,
for their employees.
for their
But there is
thereafter.
an agreement in between the government and the company regarding the 8 flats. But after allotment 8 flats, my lord, allotted my lord, our workers for staying there.
For how many years? It's only for the service tenure.
Only for the service tenure. That is the whole difficulty.
But then you do not have any agreement with the housing department with regard to for how many years you let out or
It's
something. isn't
continuing,
it?
my lord, still now I am paying the rent.
For you, it's all right. You are the tenant right now. For you, it's all right. But how long will your subtenant stay over there? Is there anything on record?
That is for that reason only I made an application even on the RTI. They are saying we don't have the copy because of the shifting of the offices. My lord, there is a flood, devastating flood in
Page
the
51,
Kolani
my
area.
lord, they are basically short for the document and the persons who are there. Page 51, my lord.
কি বললাম? An agreement was entered into between the petitioner number 1 and the housing department in respect of certain flats taken on rent by the petitioner number 1. Stop. The petitioner number 1 is regularly petitioner number 1 claims to pay rent in respect of the subject flats on regular basis. Stop. Grievance of the petitioner is that the said flats are occupied by the employees and / or their dependents who are no longer in service with the petitioner number 1. Stop. According to the petitioner number 1, the said flats are meant only for its employees. And the moment the employees lose the relationship with the petitioner number 1 employer, the employees do not have any right to occupy the said flats. Stop. The petitioners seek for a direction upon the housing department to initiate proceeding against the persons who are in unauthorized occupation of the subject flats. Stop paragraph. Upon hearing the submission made on behalf of the petitioners and on perusal of the documents annexed to the writ petition, it appears that there is no dispute between the petitioners and the housing department. Stop. There, however, is an issue with the petitioners and its petitioner number 1 and its retired employees or the employees who are currently not in service for any reason whatsoever. Step. The petitioner intends to evict them. Stop. The persons evict them. Stop. The court is of the opinion that the dispute cannot be. Now, the dispute is primarily a private one between the employer and the employee, writ petition entertaining such a dispute may not be proper. Stop. Next. In view of the above, the court is not inclined to exercise jurisdiction in the matter The writ petition fails and is hereby dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioners to approach the competent forum for remedy in accordance with law if so advised.
Grateful, my lord.
Grateful, my lord.
Service is taken on record. এইটা রেখে দিন তো instruction from the estate manager এইটা রেখে দেবেন record.
That will be kept with the record. Grateful, my lord.
Get.
652, I'm for the petitioner lordship led by
For the
no
respondent.
I'm paying for not today just because of he is engaged into some another.
The respondent.
Right to Information Act.
Right to information.
Did you pass on the information?
No, no, information is not our custody. So information provided by the SPIU. He may be filed a second appeal. Second appeal are disposed of or not, but that is, I need to instruction in this regard. Lordship.
When will you receive the instruction? The matter is pending from so many days.
I received the verbally instruction, Lordship, and I need to written instruction for them from the authority, Lordship.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop list in the monthly list of July.
Grateful, Lordship.
Give the names of the appearances of only the persons who are present in court.
No, 2 persons.
Yes, not anybody who is not there. Every day I can see names. Now I'll go on deleting those names. This is very unfair. Call the next matter.
653, my lord, I am for the petitioner, my lord.
Yes.
But I want to withdraw this application. My client
Why?
has given me instruction, my lord. He has already got the benefit, my lord. Really.
Got the benefit?
Yeah, he has
The
already
grievance
got
of the petitioner has already been redressed. Stop. The petitioner does not intend to proceed with the writ petition any further. Stop. The writ petition stands disposed of.
My lord, I've submitted the instruction.
Yes. Written instruction of the petitioner be retained with the records.
And wait.
654, one of I'm appearing on behalf of the petition. Kindly, due to altercation, no election was held, but name recommended and railway authority approved. Kindly page 23. The election conducting authority, the secretary. The secretary's notice on date of election on 16th March 2024, page 23.
Election of what?
Election of the trade union of the railway men's complex. Office.
What will the writ court do over here?
Writ court only grievance is election held by the union and the railway authority approved the same. Without approval, no union can be do any work in the railway premises. This is a railway employees union in Calcutta.
Yes.
The state writ maintainable already earlier filed a writ petition and directed the authority to consider their grievance. Because this.
Who is the authority? Who is for the respondents?
My lord, we are for the respondent number 2.
Authority, page 47, my lord, earlier.
Respondent number?
227.
227.
My lord. My lord, rail has nothing to do with this role of this.
Are you there for approving their election or anything?
Nothing.
Page 27.
No.
Well, page 27, can you see?
Page 27.
Page 27. Page the assistant personal officer for personal. This polling member is elected office bearer.
List of elected members.
Meeting on held on. This is the railway authority.
Members of
the union informed my lord in earlier.
The union informed and the personal officer has simply circulated.
No, page 25. Page 25.
25. This is what has been forwarded.
Forwarded because without my lord this approval.
Where is the scope of approval?
No, this is if the railway authority is not circulated, well, then the union.
Circulation does not mean approval. Where is the scope of approval? It is the union The union will select their members. The authority doesn't have anything.
Now forwarded to the railway authority, and the
Yes.
railway authority accepted the same. Well, kindly see this letter, Malad. Kachirapara anonymously.
What is your prayer?
Prayer, Malad, that order is withdrawal. Malad,
Which withdrawal?
This the withdrawal.
If it has been withdrawn, it has been withdrawn. What will the court do?
Court, Malad, this officers, Malad, as per hearing, Malad, they says that there is no scope to withdrawal, but we fail to produce any documents before the officers. But that is the document.
Please come.
And also, Malad, kindly see, Malad, the secretary's order.
The petitioner seeks a direction upon the railway authority . Seventeenth of July, where is it?
17th.
17 July 24. Prayer A.
Prayer. This is the order. Page 51. All facts narrated. The ordering portion, that is page 53. Last page, Malad.
Page 51.
51, this is the order, start. This is the fact, Malad, narrated in this case. Malad is a reason, Malad.
The petitioner seeking cancellation of the speaking order dated 17th July 2024, passed by the principal chief personnel officer of the, which railway is it?
Eastern Railway.
Eastern Railway. Stop. It appears that the said authority passed the order in compliance of the direction passed by the court on 16th May 2024 in WPA 13603 of 2024, within bracket, Sandeep Kumar Rai and others versus the General Secretary, National Federation of Indian Railway, within bracket, Men's and others. It is only Men's which is within brackets, page 47. It appears that there is a dispute in between two factions of the union, of the employees union. Stop. According to the petitioner, the railway authority has approved the union. Stop. The aforesaid contention of the petitioners are denied by the learned advocate representing the railways. Stop. It has been submitted that there is no provision to approve the committee or the members of the union by the railway authority. Stop. Upon hearing the parties, it appears that there is a dispute between two factions of two unions. Stop. It will not be
one union.
Two factions of a single union. Stop. It will not be proper to direct the employer to interfere in the matter. Stop. It will be open for the aggrieved party to approach the competent forum for remedy if so advised. Stop. The writ petition under the aforesaid facts and circumstances cannot be entertained. The writ petition fails and is hereby dismissed. Next. Dismissed.
Right, appear for respondent number 1, 3, 4, and 5.
1, 3, 4 and 5.
See, both are applying for the state respondents.
State ও আছে লিখে দেবেন yes
I'm for the state respondent.
dismissed
Secret petition and the non dismiss particular.
657. 657.
57.
657 আছে yes 657
I'm for the 57 for the state lordship. 57.
dismissed give your appearances please
Lordship.
dismissed
I'm for the pollution control board, Your Lordship.
record your appearance
Pass over this matter.
which one
I'm for the petitioner.
which one
658.
658 you want passover
Senior is in another court. He's come from.
who is the senior
Orko Pratim Chaudhary.
658 accommodation sought July give your appearance it is your appearance
Yes.
put your name in a piece of paper and hand it over all right yes
I appear for the petitioner.
I did appear for the respondent bank one. State koi.
So, the petitioner happens to a senior citizen who had an account in the Punjab National Bank, my lord. Now, the private respondent, in connivance with the bank officials, has transacted a sum of rupees 2,26,000 without authorization, for which I have lodged a complaint. A formal FIR has been lodged. I have also intimated to the bank officials about the same. No inquiry has done till date. How the money and which manner it was transacted from my account. Only the time when I came to know, I went to.
When did the incident take place?
Kindly comes to
2024.
24.
And complaint lodged?
On 24 only. Kindly comes to page 14, my the FIR.
I can see two dates in your list of dates. 10th of May 24 and 13th of June 24.
No, the original complaint malad on page 27, 7/6/2024.
Yes.
After this complaint, I have also intimated the bank officials also.
Malad, I yet to receive instruction regarding the pendency of the inquiry. What result has been come? Now, malad, kindly come to their malad complaint once. What they have stated malad in their complaint. The person malad who has lodged the FIR malad, he has willingly handed over his passbook malad during the transaction of a land malad as described by them. Malad, kindly consider the malad what he has stated before the malad police. Page 27 and 28.
The person has been duped. It is the simple thing.
Yes, someone else malad received his checkbooks and entire thing.
Took advantage of his age or whatever the reason. What the bank will do, I do not know. Please come. The petitioner's representation before the bank. Alleging illegal transaction from his bank account is pending consideration. Stop. Without entering into the merit of the same, the instant writ petition is disposed of by directing the. Who will do it? The branch manager?
No, kindly do not. Kindly do not. Let it be respondent number 7, my lord.
Why?
The branch manager, I have specific allegation. The employees of the bank are involved in it. But I have made representation to the
everyone is
number 7. The zonal manager.
Yes.
In a time frame.
Punjab National Bank to consider and dispose of the representation made by the petitioner in accordance with law. And after conducting a thorough inquiry to ascertain proper facts. Stop. A reasoned order shall be passed and communicated to the parties. Stop. It will be open for the aforesaid respondent to call for records from the respective parties as and when required. Stop. Decision shall be taken by the authority at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Disposed.
Deeply obliged.
I'm grateful, man.
My application, my lord, are unable to, my lord, correct my date of birth in the, my lord, affidavit of service. My grievance is against the other authority, my lord. I have taken 2 attempts, my lord, unable to correct my date of birth, my lord.
You are for the
Respondent number 1.
respondent number 1. Union of India. Is the Aadhaar authority represented?
I have served everybody, my lord.
What is the problem?
The problem, difficulty is, my lord, I am a pension holder.
Yes.
My lord, I need to update my documents, my lord, KYC documents from time to time in my pension account, my lord. I'm unable to do so, my lord, only due to the, my lord, in every documents, my lord, I do have a single date of birth, my lord, that is 9th of December 1936. Only Aadhaar, my lord, which is at page 15, my lord.
Right.
My lord, 2 attempts, my lord, I have taken to correct it, my lord, but I've given them affidavit, my lord.
Will you be representing the respondent number 2?
Then, my lord, your lordship allow me to
Prayer is very innocuous, my lord.
It's not a matter of allowing. Do you have the authority to appear or not? Where is the representation? Where is the representation? Page 20?
Yes, my lord. Page 20.
T3 dated 6 August 2024, my lord.
Take instruction. None represents the respondent numbers 2 and 3. Stop. The petitioner is a senior citizen who requires correction in the date of birth as recorded in the Aadhaar card. Stop. Learned advocate representing the Union of India is directed to take instruction as to whether she will be representing the respondent numbers 2 and 3. Stop. If the learned counsel is representing the respondent numbers 2 and 3, comma, the necessary instruction shall be taken with regard to the request made by the petitioner appearing at page 20 of the writ petition. Released 9th July. Not 9th. 16th of July. 16th of July. The lady is of very senior age. Yes.
661. Lordship, in 661, I am for the respondent. Lordship, respondent.
I am appearing on behalf of the state, my lord.
Dismissed.
God bless you, Lordship.
I may appeal to the state respondent.
Yes.
My lord, I am appearing for the respondent number 12 to 17.
My lord, this matter at the outset, my lord, may I submit? This is a case, my lord, where my land has been destroyed. The agricultural land is being destroyed by way of fisheries. My lord. The embankments are being cut in an illegal way. That has been then the saline water enters. My land is situated in a coastal area. So, my lord, and this is the second round of litigation, my lord. In first round of litigation, when I placed on the similar player, I filed a writ petition, and in that petition, first of all, the report from the state respondents came that there was no cut.
There was
no cut. From the state respondents, the entire claim of the writ petition has been negated. Thereafter, one special officer was appointed. At least 18 cuts were found. So thereafter, the state respondents were allowed, they were asked to remove the saline water from my land so that I can cultivate and make my livelihood. The state went to appeal. One order by the assistant engineer PWD has been passed. That order has been challenged in a separate writ petition. This writ petition is on a on the cause of action since it has been cut, but they will come with the defense that the
one order has already been passed. That order has also been challenged. My lord. These two petitions may be hard together, my lord. That is also before your lordship, my lord.
This is 21280.
21280.
Here the prayer is to register FIR against the private respondents
Private
and
respondent.
their associates on the basis of the written complaint and to investigate the case. And to arrest the private respondent and make custodial interrogation. This is one writ petition.
This is
What
one.
is the other writ petition for?
Other writ petition is is challenging the order by which this writ petition, the defense of the state respondent and the private respondents are that they are armed, protected by the order of the assistant engineer PWD.
That order of the assistant engineer is under challenge. Which item number?
It appeared on 20th June. Thereafter, it did not appear. I am just giving the writ petition number so that these two can be.
Are you aware of that
Yes,
writ
my lord.
petition?
That copy has been served. My lord, I also appeared on that in that matter.
All right.
I am not
appearing.
You are not appearing. All right. Give the number.
Because here, my lord, the son filed this writ application. My lord, their mother filed the writ application challenging the order passed by the.
Whatever. Give the number.
My lord, may I read it from my phone?
Yes.
12534 12534 125 2025.
It appeared in the list on 20th of June.
20th June. 20th and 19th and 20th.
একটু চেক করে নেবেন তো মামলাটা আছে কিনা।
Thereafter, there was.
Please come. Let the instant writ petition appear along with WPA 12534/2025. Name of the parties? একটু দেখে বসিয়ে দেবেন।
Hemlata Ghosh.
Huh?
Hemlata Ghosh.
Hemlata Ghosh versus State of West Bengal and others. ঠিক আছে? In the combined monthly list of July, let notice be served upon all the respondents.
Well, since private respondents are appearing.
They are aware. There may be others also. I do not know, and the state. Mr. Yusuf is not appearing in that matter. So you have to intimate the state also. All right? Appear in the monthly list of July. দুটোকে একসাথে দিয়ে দেবেন। Yes, call the next one.
I appear on the. Well, I pray for only not today because of that. I have the copy, but I have missed the malata. No, I'm happy. I'm happy. Sure.
I'm appearing on behalf of respondent number 1.
Then my lords. Because of that I could not annex. But I have sir.
I'm for 2 and 3.
My lord, this kindly come to page 9. Now, my lord, the petitioner self-help group has been allowed to, my lord, this the plantation of the, my lord, the particular, my lord, the marketing in the Mathura. So for 2 years, kindly come to page 9. This is my engagement letter. Your self-help group is hereby engaged for the regular maintenance of the betel nut plants and other plants for Mathurapur Kishi Bazar. The chairman Asira highly appreciated invented the plantation of betel nuts and other plants. So your self-help will care the plants and will allow 8,000 per month for the job and will continue for 2 years. So in spite of performing our duties, well, the salary or honorarium has not been.
8,000 rupees for 2 years.
Nothing. In favor of the self-help group, nothing has been paid.
This is only your prayer. All right.
No termination apart from this.
No, termination is different. You worked for 2 years.
Yes.
All right. Yes.
Well, it's only money claim. Yes. I will definitely look into it without going into technicalities of it. I will ask my client to look into it. If he has worked in my client's days, common usually delay in payment, but will not make payment.
And the amount is very meager amount. It's not a huge amount.
I will
it is a self-help group.
1,000 per month per mile the member getting 1,000. Because of that, there are 20 members. Rotation wise, mile they are working there. Mala 2 days, 3 days they are working.
Please come.
Lordship, but I would only request your Lordship, I will inquire one thing, because since there is a plantation issue.
Where is the issue? There is no issue. It is you who have given him the permission, given the self-help group the direction. Then where is the issue?
Secretary has come before your lordship.
No. What I'm only saying is before your lordship is, in these matters, many times they sometime execute, sometime do not. Plantation, because they will put
The court is not going into anything. Whatever you are submitting, it is absolutely impromptu. You do not have any instruction.
I will.
Then why will
not only
you
I will
make
take
submission?
instruction. Not only that, lordship, I will take instruction.
Whatever instruction you feel like you take. The petitioner refers to a communication made by the Secretary of the South 24 Parganas Regulated Market Committee on 17th December 2021. Wherefrom it appears that the market committee directed the self-help group to take initiative for plantation of betel nuts and other plants, and the market committee will allow rupees 8,000 per month for this job. Stop. The job. Now, the engagement was for a period of 2 years. Stop.
With effect from 1st of January 2020.
With effect from 1st January 2022. Paragraph. Grievance of the petitioner is that the payment has not been made. Stop. Learned advocate representing the market committee is directed to take instruction released on 16th of July.
I'm deeply.
Next. Dismissed. Record appearance.
Let the report be kept with the record.
Please report.
Well, I am appearing for the petition.
What is the matter?
I am appearing for the petitioner in both the matters,
yes,
both are similar. Whatever petitioner was given as armed license in the year of 2015. Thereafter, it was renewed time to time up to 2020. But thereafter, it was deposited for further renewal when the renewal order refused by the number 2 district magistrate. And a proceeding was started by which you will also kindly see a proceeding. I have annexed the proceeding copy by which, according to them, no such license has been issued from this office. Page 14. Sorry, I have page 14. And come page 14 bottom by the office. Against which, my lord, there is a provision of appeal under section 18. I have filed an application for obtaining certified copy to prefer an appeal against the order. That copy has not been supplied. For which, my lord, I am not in a position to prefer an appeal and take the law.
So you want certified copy of the order dated 30th of
last page 23, order sheet. Painted order sheet, I want certified copy to paper.
Last order.
My
Date of final order 30th of November 2021, page 23. This is your application.
Yes, ma'am.
DM Barasat.
Yes. This is a
My lord, I appear for the next item, 666.
Yes.
similar. Both
I have the report.
What is it? You are not giving the certified copy?
My lord, that on that score, my lord, I have no instruction. But
Then?
the entire my lord proceedings were there. He was
No,
given,
he wants to
was
prefer
given
an
the-
appeal and he wants a certified copy. Why is it not being given?
section 18 provides.
Please come.
My lord, in your lordship, kindly allow me to prefer an appeal. The time part is there, my lord. Unless I get it, I will not able to file it within the time.
What is the date of the application? Page 23. What is the date? It is, I cannot read it.
On the bottom, my lord.
Where is it? Bottom?
2610.
Where do I get that? কোথায়? State of West Bengal, party নাম লেখা রয়েছে, inquiry report. Where is the date of the application?
My lord, there is also
This
no
number.
date in my copy.
30/11/21.
That is the date of the order.
Yes.
When did you make the application?
On the bottom there is a
No.
Nothing is.
Bottom also, nothing is mentioned.
they will kindly direct them to supply certified copy.
Of provided I see that there is an application.
I shall file a fresh application.
Then you are already time barred. It is 2021's order.
That is the copy have been supplied by the petitioner. What can be done?
That is petitioner's fault. Nothing doing. Achha, the petitioner is aggrieved by the order dated 30th November 2021. Passed by the District Magistrate, North 24 Parganas. Under Arms Act, 1959. Stop. He intends to prefer an appeal against the same, but cannot do so, allegedly because certified copy of the said order was not provided, despite application being made for the same. Stop. Paragraph. On a perusal of the annexures, it appears that though there is a photocopy of an application for obtaining certified copy, but there is no proof of submitting the said application before the authority. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the District Magistrate, not 24 Parganas, to deliver certified copy of the order dated 30th November 2021. No.
But my lord, he
certified
has asked
copy
for
certified
now
copy.
for 15th December 2020.
In your matter, it may be 15th. Here it's 30th. কি বললাম? To deliver certified copy of the order/documents sought for, provided there is a proper application in place. Stop. In the event no application is found in the records of the District Magistrate, then the petitioner would be required to file a fresh application for obtaining certified copy. Stop. If the application for certified copy is in order, then certified copy shall be provided to the applicant immediately thereafter. Writ petition disposed. Service taken on record, none for the state. Next one, same order will go down. Already date, মাঝখানে কেন date তো বললাম না? Same order. Yes.
667. My lord, the report may be taken.
Yes, report taken on record. Next matter.
667. Lord, I am for the petition.
Yes.
I am reviewing for the state respondent. So may I file the affidavit of service? My lord, the private respondents, my lord, the endorsement comes door locked, but the peculiarity of this case is, my lord, they could not be served. Why, my lord, I am telling your lordship, then your lordship will. My lord, this is my lord, the petitioner, my lord, is the owner of a dwelling house. Now, my lord, in the ground floor of the dwelling house, pursuant to an order of the SDO in Senior Citizens Maintenance and Welfare Act, my lord, my mother, along with my sister, was allowed to reside. Now, my lord, they were there, my lord. Now, for the last 1 year, my lord, they have left the place, and my lord, their whereabouts are not known. Now, my lord, since my lord, and they have put the padlock. Now, my lord, since my lord, I cannot break open the padlock because they pursuant to the court's order, my lord, they were in possession, my lord. So therefore, my lord, I made a representation application before the SDO as well as before the police authorities, my lord, to inquire into the matter, and my lord, to take necessary steps or to allow me to get hold of the possession.
Who is the owner of that property?
Myself. There is no doubt with that. But the orders are all there.
All
I
right.
am the owner. It was gifted to me by my father and my mother. Now, my lord, subsequently, my father has expired. Now, the
Yes.
ownership is not disputed, but the right of residence and all those things, and as a caregiver, my lord, the sister was also allowed to reside. Now, my lord, they are
The gift was not revoked by the
No,
SDO.
no. That is
All
not
right.
the case.
All
That
right.
is not the case. Everything is on record.
Hmm.
Now, my lord, that is the reason why I am asking for, my lord, that let there be an inquiry by the SDO or through the help of the police authorities. Let it be apprised before your lordship. If the petitioner's, my lord, statements are found otherwise, my lord, I have no case. Or else, my lord, appropriate orders will be passed. Because, my lord, the house belongs to me and they are not there. My lord, I am in such a
But
peculiar.
then why will the writ petition be entertained? You've got a
Because-
private dispute between your
No, it's
mother
not a
and your
private dispute because, my
sister.
lord, they were, my lord, pursuant to the court's order.
Maybe
It
the
is not a
court's
civil
order is
dispute.
there, the court's order has been worked out. Now there is
No, right of
different
residence
dispute.
was there. Now, my lord, at this stage, my lord, their residence was their right of ownership or their right title and interest is not the issue here. Here, the issue was, my lord, that the right of residence and, my lord, as a caregiver, my lord, the
I have
sister-
followed it. Now the order of the SDO has been acted upon.
It was acted upon. Now, for the last 1 year,
This is a subsequent cause of action that has arisen. They have gone
that
away,
is
they
the
have fled
reason.
away.
Now, my lord, if I open,
Why will the SDO
if I
go
break
and
open the
inquire?
padlock, now, my lord, they will bring out a case
They will-
of theft and
It is-
everything.
It is up to
And
them.
I cannot, my lord, I kindly appreciate this condition. My lord, I cannot take out any separate civil suit for this reason.
You
My lord,
can.
because, my lord, there is no dispute with regard to title. There is no claim of title in the property. There is no, my lord, rival claim of title.
Keep waiting. Apart from title, you can.
I was
approach
waiting for the
civil
last
court
1
for-
year, my lord.
No, I do not think the court will.
My lord,
entertain.
kindly, my lord, let there be an inquiry on this issue,
No, no.
and thereafter your lordship will dispose it of.
Certainly not.
Let the facts be
The-
come out before your lordship.
The writ
Let there
court
be an
will be a fact-finding court now.
Not a fact, my lord. Everything
petitioner
was, my
is-
lord, pursuant to the order of the SDO.
Petitioner submits that the private respondent number 6, who is her mother, and the respondent number 7, his sister, his mother, and his sister, occupied a house recorded in the name of the petitioner in terms of the order passed by the subdivisional officer under the provisions of welfare provisions of Maintenance and Welfare of Parents and Senior Citizens Act. Stop. When was this order passed?
Well, it was passed 2015.
In the year 2015. Stop. The mother and the sister stayed at the said house for some time, but for the last 1.5 years. How many years?
Yes, my lord. Since May 24.
But since May 2024, the house has been kept under lock and key, and none is staying there. Stop. The petitioner is not aware of the whereabouts of his mother and sister. Stop. The petitioner has approached the subdivisional officer
as well as the police authorities
and the police, and for causing an inquiry. Stop. As there is no response from the end of the authority, the instant writ petition has been filed. Stop. Copy of the writ petition was sought to be served upon the private respondents at the address which is at the address which is currently padlocked. The writ petitions, the postal articles have returned unserved with the postal remark, door locked. Stop. Affidavit of service filed in court is taken on record. Stop. The unserved writ petitions are returned to the learned advocate on record of the petitioner, retaining the unserved envelopes. Stuff. What is your submission?
My lord has already clarified nothing to, my lord, this is a purely a civil dispute. What we are.
Civil dispute is not there, my lord. In that
Learned
event, my lord,
advocate.
There is an
liberty
order
may be
for
granted
their
to take
possession.
appropriate steps, nothing more.
Not about the-
Because, my lord,
আমি
civil
লিখুন
dispute is not
যে,
there.
upon hearing the submission made on behalf of the petitioner, it appears that the order passed by the subdivisional officer under the aforesaid act has been worked out. Stop. Currently, a separate and a fresh cause of action has arisen. Stop. The dispute between the petitioner, his mother and sister cannot be resolved either by the SDO, or the police. Neither can the writ court enter into a private dispute for resolving the issue. Stop. In view of the above, the court is not inclined to exercise jurisdiction in the matter. It will be open for the petitioner to approach the competent forum for relief if so advised. Writ petition dismissed. Police officers
But kindly don't indicate, my lord, dismissal, my lord, your lordship will kindly dispose it of, my lord, otherwise.
Otherwise what?
This much relief, my lord, kindly, my lord, I am on it. My lord, dismissal has, my lord, this consolation must be given.
But word itself carries a lot of.
My lord, your lordship will kindly appreciate my predicament. Your lordship, my lord, knows, my lord, I am, my lord, dismissal word should be, my lord, it will have far-reaching implications because civil dispute is not there. But kindly, my lord.
Grateful.
Disposed of.
Grateful.
Disposed of.
Grateful.
Take back the writ petitions. Take back the writ petitions and only the envelopes will stay. Dismissed.
My application. Before I start, my lord, there are two respondents, my lord. The first is the Eastern Coalfields Limited. My lord, twice service attempted, came back with the remark insufficient address. But my lord, respondent number 2 is at the same address. He has received it.
ECL is represented. আজকে না কালকে একটা হলো না ECL?
Mr. Shivshankar Banerjee generally appears, but I don't think he's the advocate on record.
You can inquire who appears at least so that you can serve notice or something. But yesterday somebody else appeared.
Number 2 has received it.
Okay. On matter Eastern Coalfields Calcutta মামলা হলো না আমাদের? কিছু জানি না।
My lord, twice attempted. Address given in the agreement. Comes back with the remark, my lord, insufficient address.
Eastern Coalfields হ্যাঁ একটু খুঁজে বার করো তো কে ছিল?
And my lord will see respondent number 2, same address.
What is the relief sought for?
My lord, quashing of a notice of termination and my lord, invocation of bank guarantee. My lord, I would show, my lord, from the fuel supply agreement that for the lock-in period, I did not terminate the agreement. But in that period, there was COVID. I had intimated them that is the reason why I could not lift the coal according to the agreement. Intimated right from May 2020, no reply. Thereafter, my lord, termination made in 22. I had asked, terminated the agreement in terms of the fuel supply agreement, asked them to return my bank guarantee. No reply. 24, they
So their
wake up.
presence is required. Without their presence, it will be difficult to adjudicate.
It's been served, my lord, and has been served way back, my lord. Has been served in 2024. August 24.
চিনতে পারছি না আমি। None represents the respondents. Stop. Let a further notice be served. Give your service.
My lord.
Let a further notice be served. Take back the writs. Order দিয়ে দেবেন। Let further notice be served. Released in the combined monthly list of July.
Any answer?
17.
Dismissed.
I'm appearing, my lord.
For whom?
for all the respondents.
Please enter your appearance. It's being dismissed for default.
671 and 672, I'm praying for an accommodation, my lord.
For whom?
I'm led by Mr. Dhiman Banerjee, my lord.
For whom?
For the petitioner, my lord.
I'm appearing on behalf of the respondent number 5 and 6.
5?
5 and 6.
5 and 6. Accommodation sought July.
My lord, my senior is appearing on behalf of respondent number 1. She is currently on her legs. So please kindly pass it over.
Which item?
Item number 671.
71?
Yes.
All right, please enter your name. 672? Next monthly list. Which authority? Municipality? It will appear in the next monthly list. You are for the
state.
Very well. Next monthly list. Give appearance, please. Don't give appearances of anybody who's not there in court.
May I please, Your Lordship? This is my application. I served Your Lordship. All being.
He is there online.
In the year 2013, I participated in an auction proceeding.
Online. Yes.
Participated in an auction proceeding
Yes.
for purchasing a seized vehicle by the Forest Department. I became a successful bidder, and thereafter I was asked to put in the entire cost amount. I put in the entire cost amount of about 4,235.
When was it?
It was in the year 2013.
All right.
Thereafter, Your Lordship, I made applications, and there was interdepartmental communications with regard to changing my names.
Ownership.
And yes, Lordship, that was not done. Twice earlier, moved before this honorable court. There's a direction, my lord, for considerations and doing necessary steps. My lord, all the times.
Where is the vehicle?
Vehicle, it was given to me, but I couldn't do anything. It's a scrap now. I'd spent money and couldn't ply the
vehicle purchased.
And last
was,
Your Lordship,
offender was found to be, the vehicle was found to be on finance. Now, the moment, my lord, this gentleman, after purchasing the vehicle from this forest department on auction, he went for transfer his name. RTO says, we can't, it's on finance, hypothecation, get the clearance. Now, my lord, we are after that person from whom the vehicle was seized, untraceable absconding. Third round of litigation.
What is to be done now?
now made a representation because can't do anything with the vehicle.
What do you want? Representation for what?
Money.
For money back?
Yes. Because I can't do anything with the vehicle. Even if the documents are being made in my name, I can't buy the vehicle. Because of
2013.
Yes. I can't do anything with the vehicle. I made a representation, Your Lordship, at page 42. I said that my money.
2014, I can see a writ petition was filed.
Twice.
2014 itself. From 2014, what were you doing?
The last one, Your Lordship.
Orders, there are two orders. One is at page 33 by coordinate bench, another at page 39.
39 is the RTO's order.
Two recent orders by RTO.
29 and 30, two orders are there. Page 29 and page 30.
29 and 30. Yes. What is your instruction? What is
the instruction? They are in favor. The respondents, my lord, they are in standing in favor of the gentleman.
Yes.
That yes, it
so
has to.
So you have to return the money.
It has to be transferred. My lord, may I respectfully invite your lordship to page, my lord, 8 and 9, my lord, of this SF given by the DFO. Kindly see page 8 and 9.
Yes.
They are in favor. The DOF is in favor. They're quoting certain judgments also.
No, it's all right. Then the money has to be returned.
Then we are page 44, Your Lordship, we had stated. We stated that the money.
1 minute. Yes.
Miller kindly sends Miller page 42 Miller to the concerned authority whether it can be considered Miller this representation at page 42 Miller.
Why for consideration? Lordship to direct them.
You come up with a after consideration you come up with your report. Otherwise, a fourth round of litigation will come.
Endless process.
And this 2 lakh of rupees in 2013 is gone. As it is gone. Because you deliver a document without deliver a good without a document. It means nothing.
Lordship kindly Miller direct.
Isn't it?
Lordship. Let page 42 be acted upon and thereafter we shall place a report.
The petitioner prays for consideration of the representation. Annexed at pages 42 to 44 of the writ petition. Who sold this?
This
DFO? No.
DFO.
DFO.
Makuda.
Page. Who has given the instruction? Chief conservator.
Instruction principal.
In that case, chief
conservator is forwarding the letter.
Yes, let him consider. Acha. The respondent number 2 is directed to consider the said representation and pass a reasoned order. Acha. Let the reasoned order within 25th July. Release the matter on 29th of July. Reasoned order shall be placed before this court on the adjourned date.
Lordship.
Service is taken on record. The instruction forwarded by the Chief Conservator of Forests, dated 12th September 2024, be written with the records.
Obliged, Lordship.
74. 634.
I am for the private respondent.
Dismissed. Record appearances.
675.
I am for the respondent.
Yes.
Bank.
Dismissed.
676.
I am absent for this day.
All right. Dismissed.
677.
ডাকতে থাকুন।
678.
Petitioner, ma'am.
Yes.
The petitioner made a representation for the raising objection.
I cannot hear.
Mic ne.
और मतलब ये पाइपलाइन मालोट के इंस्टॉल मालोट के फॉर मालोट के प्रधानमंत्री की उजरा गंगा पाइपलाइन प्रोजेक्ट on the basis malot notification was issued paragraph malot ke 3 malot.
You have raised an objection?
Yes, my lord.
Why?
Kindly, my lord, turn page 19, my lord. These objections not yet, my lord.
Why? What is the objection?
My lord, 19, my lord.
What is the objection? Why are you objecting?
This is only line. There is alternate, my lord. Survey was made, my lord. Other, my lord. There, my lord. There, kind, my lord. Map, my lord. Kind, 1 second, my lord. The turn, my lord. 18.
And this was in 2021.
Yes.
My lord.
Has the pipeline not been laid by now?
No, my lord. My lord, this is the, my lord.
It is still continuing.
Yes, my lord.
What? Yes.
My lord, there is not yet. My lord.
Then it has been dismantled. They are not interested to proceed. No cause of action as on date.
No, my lord. Thereafter, my lord, 22, my lord. There is my lord, 22. Again, my lord, pending of the objection, 2022, my lord, again notice was issued.
And thereafter, my lord, all the villagers, my lord, raise
Notice, my lord,
objection.
basically ask them whether they have any document to show that this which land is belongs to them and all. Kindly takes that notice.
This is the notice, my lord, notice 6. My lord, no, I have to raise an objection under section 3, my lord.
6 of what? Land acquisition?
No, my lord. 6, my lord, this is the my lord, act, my lord, the petroleum. My lord,
Petroleum and minerals pipelines.
Pipeline acquisition
of right.
Huge in land act 1962. My lord, if the my lord 3, my lord, kindly, my lord.
Keep the header. 6.
Yes.
Declaration of acquisition.
My lord, this is the my lord, section 3, my lord, first,
Objections is 5. So 5 must have
my lord,
done,
hearing,
then
my lord,
6 comes.
Then, my lord, first, my lord, the notice, my lord, section 3. If the section 3 is, my lord, notice, my lord, the raise your objection, my lord, 5, my lord, hearing, my lord, and then, my lord, thereafter, 6 will come. My lord, the objection is remain pending. My lord, the objection will be,
What about the 3 stage?
My lord, remain pending, my lord.
What? 3 publication was made?
No.
What no?
My lord, thereafter, my lord, come to survey. My lord, on the my lord, that the one side, my lord, survey, my lord, another side, my lord, pipe the desired to the install. This is the my lord, objection, my lord, all the villagers raise your objection. My lord, last, my lord, objection with the raise, my lord, 2023. My lord, page 22. This is the my lord.
Which authority? Which authority?
My lord.
It must be the central government.
Project.
Yes.
Is it implemented through the state authorities?
No, my implement to my lord,
they have
yes.
Bishesh, my lord, if lordship takes, my lord, the office which they have used, my lord, that Bishesh Bhumi Odhikarik Jela Howrah, page 21, my lord, kindly takes.
But then it must be done by the.
And my lord, in the stamp, my lord, office of the special land acquisition collector within bracket central. Page 21, my lord, kindly takes once.
Hmm. 6-1 notice has been issued. Dag number 682. What is your dag number?
My lord, my dag number, my lord, 60. My lord, 681.
81. They are taking 682, not taking 681.
RS, this is the RS, my lord. This is the alert, my lord, new dag, my lord.
What is the dag? Page 21, I can see dag number 682.
My lord, this is the RS, RS.
What is your RS?
Kindly, my lord, turn my page 20, my lord, page 20, my notice, my lord, the alert dag, bottom, 6.
Dag number 681. This is LR?
I don't LR. LR porcha, my lord, have porcha, annex, my lord, 11, page 11, my lord, have annex, my porcha.
And it's 0.10 hectare. Whether you fall within that or nobody knows. 3-1 notice is there. After getting the 3-1 notice, did you raise any objection?
Yes, my lord. This is the objection, my lord. Kindly, my lord, page, my lord, 1919, my lord.
That is 13, 12, 21.
19, my lord, page 19, my lord.
Page 19 is
19, my lord.
December 2021.
My lord.
You submitted it before the BLRO, before the block development officer.
Yes.
Special.
What special? The stamp of BLLRO, Shampoo to Howrah.
Where is before the land acquisition officer? LAO, right side top. Land acquisition officer, General Howrah. Acha, pipeline.
ফোন করে বলতো ফালতু এদের যত কাজ নেই কম্ম নেই
বিশেষ ভূমি আধিকারিক হাওড়া অফিসের ঠিকানা হাওড়া আচ্ছা please come Pradeep. The petitioner's objection filed in terms of the petroleum and minerals pipelines, bracket open, acquisition of right of user, inland, bracket close, Act 1962 is alleged to be kept pending. Stop next. Without entering into the merit of the claim of the petitioner, comma, the instant writ petition is disposed of by directing the respondent number 4 to consider and dispose of the petitioner's objection in accordance with the aforesaid act after giving reasonable opportunity of hearing to all the necessary parties by passing a reasoned order at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to all the parties immediately thereafter. Stop. Learned advocate for the petitioner is directed to forward a copy of the objection along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed.
Grateful.
আইনের নামটা দেখে বইটা ফেরত দিয়ে দিন।
Pradeep.
680. 680.
Statement.
Dismissed.
Six 681.
I'm for Durgapur.
Matter is regarding, my lord, the tourism incentive scheme. In the tourism incentive scheme, my lord, what I have entitled, they have granted the eligibility certificate, disbursed the partial amount, and thereafter, my lord, they have stopped.
Scheme, is it a subsidy amount or
Yes,
what?
yes, incentive scheme under the tourism incentive scheme. So, my lord, what's happened? It is not a case that it is not, my lord, paid. It is approved, it is partially paid and partially withheld. My prayer before your lordship to direct them, my lord, to, my lord, pay the balance amount.
Admitted.
Because it is an admitted amount. Kindly see my demand justice, lordship.
No, your demand justice will not do. Show me the scheme.
My lord, the scheme is I have annexed, my lord. That is at page 10. That is at page 10, my lord. This is a scheme. I have, my lord, set up on the basis of that scheme, my lord, a huge resort and hotel at Purulia, my lord. And that, my lord, under that scheme, I am entitled to the capital subsidy scheme and the interest schemes. That I have taken loan from, my lord, if your lordship come to page.
I need to take, I'm being led by Mr. Tanoy Chakraborty. Apart from that, I need to take instruction because this incentive, lordship is very well aware of this incentive scheme matters, your lordship. These are not plain and simpliciter matters. Whether they are qualified under the scheme or not, I have to take instructions, your lordship.
What were you doing for so long? When was the writ petition served?
Lordship, it has sprung after a long time, your lordship.
And so you will sleep.
No, your lordship.
Then?
I need to take somewhere in the process. This thing instruction has been lost, I believe, your lordship. Kindly give me a day's time, your lordship.
Page 21. What is saying, my lord, without seeing the record, my lord? 21 is my.
August 24, it was served upon you.
There and I have not
Yes,
been served. There is a
lordship.
can also, your lordship. I believe they has filed an application also.
In that matter, no, my lord, there is a no.
Can koro na ekhane can dekhachhe.
Please come. The matter relates to. Please put in appearances of persons who are present in court.
Absolutely.
Every day I can see names on top of you, not present.
Lordship, that's
Please do not do
will
that.
happen.
The matter relates to the West Bengal Incentive Scheme, 2015, published by the Tourism Department, Government of West Bengal. Learned advocate representing the learned advocate age. According to the petitioner, partial payment in terms of the scheme has been made, but balance is pending. ঠিক আছে, learned advocate for the state respondent seeks time to take instruction. Stop list in the combined monthly list of July. What is the application about?
The application is, my lord, for early date of
আচ্ছা, ওটাকে dispose করে দিন. But the application is not on record. When did you file that? Before which court?
For your lordship, my lord.
14?
Yes.
Court number 14? আছে? Keep it in the record.
Application file হয়েছে তো বললেন কেন?
Disposed.
We have not received.
Yes, that is being disposed of. Yes, next one.
Much obliged.
82.
I appear for the respondent number 5.
5. Dismissed.
My lord, on behalf of the petitioner, my lord, I'm praying for only not today, my lord.
Only not today, we'll take you to the next month.
My lord.
Yes.
My lord.
Adjourned. July. Has appearance been given? Not supplied for the petitioner. Yes.
84, I'm paying for not this week, my lord, because the learned advocate appearing on behalf of the petitioner, my lord, is sick.
Very well. Give your name.
I'm for the mother dairy, my lord. Respondent.
Enter your appearance, please.
This is, my lord, my application. It's a short matter, and my lord, slightly embarrassing for me to, my lord, trouble your lordship with this. My lord, between 2018 and 2021, my lord, I had represented, my lord, the state of West Bengal as a senior counsel before the Supreme Court of India. My lord, on, my lord, the instructions of the standing counsel. My lord, I had, my lord, sent my invoices and everything. My lord, about 3 crores plus of legal fees is pending. And I have, my lord, addressed, my lord, several letters to the office of the legal remembrancer, my lord, also to the
Show
chief
me your
secretary.
affidavit of service.
Yes, my lord. I was also, my lord, the additional Solicitor General of India between, my lord, 2005 and 2008.
Inquire, you didn't serve the GP's office? Where is the service on the GP? It's only through mail. Inquire who's appearing for the state.
My lord, we've served, my lord, Mr. Anirban Ray, my lord, through email.
Inquire who's appearing from the
Very well, I'll do that, my lord.
state and come back. None appears on
Okay.
behalf of the state respondents. Let further notice be issued to the learned advocate representing the state. List in the combined monthly list of July. Service is taken on record. Yes.
686, my lord, I'm appealing for the petitioner. My lord, this matter has become infructuous in view of the, my lord, order passed. My lord, in and first appeal, my lord, being number 272 of 2024.
This has become infructuous. Learned advocate for the petitioner submits that the instant writ petition has become infructuous in view of the order passed by
Honorable Division Bench in FAT 272 of 2024.
date.
Lord, order date টা বলুন। Lord, give me a moment, sir.
নাম্বারটাও দেখে নিন একটু ঠিক বলছে কিনা name of the party of state. Yes.
Like the date, Lord.
Please put it down in a piece of paper and hand it over. Get it. Infructuous. Sir, online আছে।
Infructuous হয়ে গেছে।
Yes.
For the petition, lordship, I need to go through the file, lordship. Kindly, accommodation should be given, lordship.
You need to go through the file.
Go through the file, lordship.
What
I
are you
don't,
doing for so long?
lordship. Kindly, the suddenly come up, lordship.
Suddenly come up. It is there in the list for so many days, for months together.
Kind enough, lordship. Kindly give a 1-day accommodation, lordship. I believe.
Kindness will not be shown always. Please make sure of it.
I will.
Next monthly list.
Grateful.
688.
Dismissed.
689.
My lord, I'm for the petition. I appear for the state. But it's a tender matter, my lord. The project was for installation of submersible pump. Now, my lord, I participated in the tender by filing all requisite documents, my lord. On 20th August 2024, I was asked to be present with all papers. On 20th August, my son went there to the office, and the goons represented or backed by the present dispensation under gunpoint, my lord, refrained me from submitting those documents. Immediately, I had to come back, and on 23rd, I made an FIR, and police arrested 3 persons. In the meantime, they have just given that tender, I mean, the offer to the choice man. This is the net.
So what can be done now?
Now, my lord, your lordship kindly see.
Work order issued in 2024.
What is to be done now?
But my lord, your lordship kindly see.
And you have withdrawn.
I was the lowest bidder. I was the lowest bidder.
No, all said and done, what is to be done now?
My lord, in fact, my lord, your lordship may kindly ask them to submit before your lordship the bid document, so that henceforth it cannot be.
Please
repeated,
come.
my lord.
Kindly see page 58 once. He has
The-
withdrawn.
The petitioner. Now, petitioner, the matter relates to a tender which was floated way back in 2024. Stop. The work order has since been issued, and at such delayed point of time, there is hardly any scope to interfere in the matter. Stop. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Service is taken on record. Yes, next.
It's 90.
I appear on behalf of the petitioner. Lordship, this is for consideration of my representation. I'm a resident of a neighborhood wherein a pond.
You are a resident of
a neighborhood where the private respondent number 8 is converting a pond into a factory premises. Your Lordship, I've made the representation. Your Lordship will see the representation at page 37.
Show me your service, please.
Lordship, my affidavit of service. So the land is a Sali land, which your Lordship will find from page 29.
Please come. The legal representation filed on behalf of the petitioner alleging illegal filling up of a water body is pending consideration for a considerable period of time. Stop. None represents the respondents despite service. Affidavit of service filed in court is taken on record. Stop. Which area will it be?
Lordship, this is
Gram Panchayat?
Lordship, Gram Panch. Lordship, this is Sonarpur. Block Sonarpur, police station, Sonarpur.
Respondent number
24
4.
Parganas.
Consider representation. Legal representation dated 24th of May 2024. 12 weeks. Huh? What could be? Yes, it will be
Great.
considered.
Great.
691.
My application, my lord.
Yes.
The affidavit of service, my lord, is complete. Yeah, I just file it, my lord. My lord,
Union of India is your other side. What is?
Principally, my lord, the respondent number 3 is the authority that I have made allegations against. That is, my lord, admittedly a wing of the Union of India. Metal and Steel Factory, Ishapur. It is one of the factories, my lord, from which certain products, my lord, are manufactured and sent to railways, the Indian military services and all of that. My lord, there's a work contract that is given to me. I am, my lord, required under the work contract to pick up what are known as, my lord, box. My lord, I'm forgetting the box, my lord, axles. I'm supposed to pick that up. I'm supposed to forge it into, my lord, boxen axles. And I'm supposed to send it back. According to the agreement, when it was executed in my favor, my lord, there was supposed to be a bank guarantee, which is called a material bank guarantee, and a security deposit that I had paid, my lord. That was a precondition. Under that agreement that was executed, there is a term that states that if more than 3% of the goods that I give is rejected, then they will be entitled to encash my bank guarantee and then enforce it against me. That goes absolutely in their favor. Lordship will, my lord, kindly take up that page once at page number 37.
What is your prayer?
My prayer is today there were certain disputes that had arisen with respect to the measurements of the goods that I had given. They don't notify me whether that is 3%, less than 3%. They say 45 numbers of units. Then there's a dispute. Then there is a communication. I'll directly take your lordship to communication. I showed 2 pages. Lordship takes up 73 once.
Yes.
This should sum up, my lord. 73.
Yes.
Lordship looks at, my lord, the second paragraph starting with fraud machining operations. Only 2 vendors, namely Calcutta Gears Private Limited, Howrah and Mohta Coal, that is me, are engaged by MSF. At initial stage of machining, Mohta Coal Company had made a 0.5 mm steps in wheel seat
area in place of taper in 45 units of axle. However, all other dimensions were found okay. Out of 45 units, 18 numbers were dispatched to RWF Bangalore after rights inspection. After joint inspection, various so-and-so performed at RWF, the same were returned to MSF for rectification. Lordship kindly comes to the second last paragraph. MSF Ishapur is a Government of India production unit under Ministry of Defence. Rejection of above axles would result into wastage of huge amount of government money. Considering and accepting the above proposed rectification process will certainly promote and help our approved MSME vendor, that is Mohtakul, which is me. Also, we will be able to supply finished box and axles with more number of quantities on regular basis as per requirement. In view of the above, it is requested to grant one-time relaxation considering the above 45 numbers finished box and axles for remachining. Only minute reduction in wheel seat diameters which will not affect final assembly. If considered, above axles will be issued to RWF Bangalore after re-inspection. This letter is dated 10th of February 2024, issued by the respondent number 3. Now they were supposed to await for the outcome of their representation. They don't wait for it. Suddenly my bank guarantee is encashed. And the security deposit is also encashed. But this gives rise to a very suspicious situation, which is why we came by way of a writ application. For, in fact, for refund of money, which is otherwise also permissible. But I was carrying a judgment. I'll just show one sentence of the judgment.
No, not the judgment. Whether the agreement between you permits that.
Yes, Lordship kindly takes up page number 37 once.
You do one thing, you serve and you come back.
I'll reserve.
Otherwise, no order can be passed.
Any
in their absence, if any order is passed, then
because my prayer is for refund, so they'll have to be there.
yes, none represents the respondents. Stop. Let further notice be served. Released in the monthly list of July. Give the service.
Yes, affidavit service file. Yes. Lordship kept it in the monthly list of July.
Next, this Monday, the monthly list will be published.
Extremely good.
Item number 686, the server copy of the judgment will
Only the top portion, the date, the cost title is required, nothing more.